My lord, I crave the lordship's indulgence in mentioning item 38 and 39. A little bit of accommodation on 23rd March, my lord.
38.
38, 39 both.
Ah.
I've taken consent of my learned friend. The short adjournment, my lord, for 23rd March.
From 23rd to 27, I will be out of station. Thereafter, any date.
These are for condonation,
My lord, yes, yes.
substitution,
Right,
abatement.
my lord.
These are to be considered only.
Yes, yes.
There is nothing serious.
Factually a bit complicated. My learned friend, my lord, informed me that matter is there today.
Hmm.
So, my lord, that way I could not prepare also.
No, we are not going to consider the review.
That will come later on.
Ah.
If subject to this, if his lordships allows that.
Okay. On the request of Mr. S. Dr. Senior Counsel, you are present or absent? We-
Then April sometimes.
Before that, then 28th. 18?
Yes, yes. 18.
Okay.
March.
Land Senior Counsel, applying for the petitioners. Release the cases on 18. Miss P. Aforesaid, Learned Counsel for the response number 2. As agreed to the said prayer. First of
Much obliged.
But I think to mention for listing of a motion matter on Monday.
okay. What is your subject?
Challenge the minus of the tender negotiation committee. Technical bid was rejected. Monday.
Okay.
I have similar prayer for listing on Monday, my lord. The matter regarding, my lord, removing the name from the website of the petitioner voter list.
Voter list.
Yes. Lordship already passed an order, my lord.
Okay.
Item number 32, the tender matter. Here, matter the petitioner is referred as statutory appeal. Today is the date of hearing.
This is that matter where Lordship had directed the authority to.
Okay.
Appeal matter. Today is the date for hearing matter. Let it be after 2 weeks or 3 weeks. Only in the meantime, towards the outcome I will place.
Okay. Mr. KP Pathak, Learned Counsel for the from key is order. Learned Counsel for the petition present. Mr. B. Gogoi, Learned Additional Advocate General Assam for the response number 1, 3, 5, and 6 has submitted that the date of hearing of the appeal referred by the petitioners under section 38 of the Assam Public Procurement Act 2017 is scheduled today. He has sought, Mr. Gogoi has thus sought posting of the case after 2 weeks in order to obtain the outcome of the appeal and to place it before the court. Okay. Prayer is allowed, release the case on so and so. Any interim order? Okay.
May I please, your Lordship? Item number 5, my lord. I have the instruction to withdraw this writ petition, my lord.
Item number 32.
Item?
5.
Item number
5, my.
5. Mr. A.H.M.R. Chaudhary, Learned Counsel for the petition has submitted, on instruction, that the petitioner wants to withdraw the writ petition. Any liberty?
My lord, at this stage.
Any standing counsel forest?
I have
Mr. R.R. Gogoi, Learned Standing Counsel Forest Department for the state respondents is present. In view of the above submission made by Mr. Chaudhary, Learned Counsel for the petition, the writ petition stands dismissed on withdrawal.
Obliged.
That's for 17. And 20% time to file visual affidavit.
I will from the,
You are for whom?
and for the petitioner.
Okay, Mr. A. Dhanuka. Learned counsel for the petition has paid for and is granted how much time?
3 weeks.
3 weeks to time to file an affidavit in reply to the affidavit in opposition filed by the respondent. 3. First of Mr. A. Das, learned counsel for the respondent number 3 is present. Okay, release the case. After view then.
27 April.
May it please your lordship, my lord. May I have your lordship's kind prayer, my lord, to allow me to move this urgent motion matter on Monday, my lord. The matter relates to my lord, a holiday listing, my lord. They have put me in the holiday listing on the basis of a vigilance complaint, but copy has not been served upon me, my lord. On Monday, my lord. Deeply obliged.
Okay, supply list, item 58 and 59. That is the
58, 59, yes.
one for 2 weeks time.
You are for whom?
Respondent. I have taken permission, consent from the petitioner.
Okay. Mr.
Yes.
S. Rahman, how much time you need to file affidavit?
Fine, you just
Okay, Mr. S. Rahman, learned counsel for the respondent has sought listing of the case, has sought adjournment of the cases. 2 cases? 2, okay. With the consent of the learned counsel for the petitioner. First of all, sought for and agreed to by the learned counsel for the petitioner, list the cases after 2 weeks on a date to be fixed by the office.
May I please, your
After
lordship?
2 weeks on a date
I
to be
beg-
fixed by the office.
I beg to mention item number 36. This matter relates to settlement of market, my lord. Yesterday, my lord, private respondent has filed their affidavit. It is not on record. Can it be taken up after seven days, any day, my lord, 7 days? 37.
37.
Seven.
Okay. On the prayer of Mr. N. Hawk, learned counsel for the petitioner, place the case on so and so. It is submitted that consent has been taken from the learned counsel for the respondents to make the prayer.
Fine. My lord, in date, may, my lord, settlement of market.
3003.
Obliged.
Please, madam. I would like to mention item number 63 from the supplementary list. I don't miss another in bereavement, so the other may kindly be.
63.
63.
63.
63.
Who is in bereavement?
Mr. Nath is in bereavement,
Who not?
Dina,
Or D not? Okay. He is for
respondent number 2.
respondent number 2. Okay. Mr.
G. Anthony on behalf.
Who is the petitioner?
We have taken the consent.
Mr.
A. Ghoshal, your lord.
A. Ghoshal, learned counsel for the petitioner is present. Mr.
G. Anthony.
Z.
G. Anthony.
Anthony, learned counsel on behalf of Mr. D. Nath, learned counsel for the respondent number 2, has made a prayer for adjournment on the ground that Mr. Nath is in bereavement. Post of, in view of the ground cited, the case stands deferred. Please the case on so and so.
3003. 3003.
My lord, can it be fixed on the 18th next week?
18.
May I please, your-
30.
may I please, your lordship, I beg to mention item number 12. This matter may kindly be adjourned for a day. I'm appearing on behalf of R. Majumdar, lordship. He has
Okay.
some personal difficulties
The
today.
prayer of Miss
KLR Yanthan.
learned counsel on behalf of Mr. R. Majumdar, learned counsel for the petition. The case is passed over for the day, list the case on so and so. তারপরে counsel লিখে দিব,
30. 3003.
8. এটা মোশন নাকি মোশন কোনকাল লিখো which one?
Item number 8. I do 20 kori ba.
8. Okay,
Maybe lordship.
1 minute. Mr. A. Mondal, learned counsel for the petition has submitted on instruction, the petition wants to withdraw the writ petition. Mr. S.R. Borua, learned junior government advocate for the state respondents, is in attendance. In view of the above submission made by Mr. So-and-so, learned counsel for the petition, the writ petition stands dismissed on withdrawal.
Maybe lordship. I beg to mention item number 41. Ali adjourn the
41.
matter. I don't know if it's a voice. Contempt. And today I will file IA.
41.
Yes,
Huh.
I kindly adjourn the matter fixed for 4 weeks.
This is for orders.
Yes, Lordship, today I will file IA for implement of party
Okay.
and for
Mr.
R.A. Ahmed.
R.A. Ahmed, learned counsel for the petitioner. 41.
Yes, 41 and 42.
Okay. Has submitted that the petitioner is in the process of filing an application for interlocutory application for implement of the necessary parties. So he has just sought for listing of the case after
2 weeks or 3 weeks. Lordship.
after a week. You have informed the other sides.
No, Lordship, I will inform Lordship.
That is not the way. Names are there. 4 names are there. We'll pass the order as and when
Lordship.
it is called up.
Daily list promotion, item 1.
May I please your lordship? Lordship, this instant contempt petition has been filed as the respondent authorities have not complied with the directions passed by this court. In its judgment dated 19th of December, the operative part is at page 37, my lord. If I may draw my lord's attention to clause 3 and 5 of page 37. Clause 3 and 5, my lord. Page 37. Corporation, my lord, was directed to
Which corporation?
the Assam Plain Tribes Development Corporation, my lord. They were directed to,
It has a standing counsel.
yes, my lord,
Who is a standing counsel?
Mr. A. Sharma, my lord.
Angshuman Sharma. Okay.
The corporate.
Can you call up? Can you inform? We'll take up after some time. No point. There is a clear instruction.
Clear
Whether they have done it or not.
Got it.
Please inform Mr. Sharma to be here.
Item number 2. Lordship, I have filed affidavit yesterday, Lordship. The affidavit,
What is the content of the affidavit?
Lordship, affidavit is not on record. Lordship, they have already acknowledged, the chief engineer, Lordship.
Yes, sir.
Lordship, page 23. Number 1, Lordship. This is the first one, MTDSW. This is the project, Lordship. Issue in this writ petition, Lordship.
Yes, Mr.
Lordship, but one lordship, PK Procedural petition in person, that referred to petition before the court order. Is going to be the case of pending. So there is no interim order for any non-payment or anything. Probably the is file of the process is not done by the chief engineer to payment. Maybe.
Well, let us have this on record and get the instruction. Because otherwise, if the chief engineer is
And then, if there is no interim order, if the order in the petition pending also.
the other petition is for what purpose?
He challenged the tender process.
Tender process.
Tender,
No, here.
they are already working with company.
What point? We are not concerned with that.
Lordship is just record by something.
Okay, we'll record your submission. Let this be on record.
Yes, Lordship.
Right. Wednesday.
No,
You in the meantime, you'll be served with a copy.
no,
Get the veracity of this statement.
no.
If it is genuine, then it's okay. We can dispose it of.
Yes,
No point keeping it pending.
no.
Mr. S. Shooter,
Yes, Lordship.
learned counsel for the petitioner, Hart, and Mr. Petitioners, and Upadhyay, Irrigation Department,
Number 1
1 to 4, Miss Miss A. Bothagur, on behalf of Learned Counsel, on behalf of Mr. P. Nayak, Standing Counsel, Finance Department, for the respondent of 5 post of Mr. Sutrada has submitted that the petitioner has filed an affidavit, additional affidavit has been filed to bring on record a statement of admission of liability issued by the chief engineer, minor irrigation, Assam. Full stop. But the affidavit stated to have additional affidavit stated to have been filed by the petitioner, is not on record. Full stop. Let's registry to trace out the affidavit and thereafter to list the case in the motion column on Wednesday.
18.3.
Give it back.
All right.
Item 3.
Yes, what about the previous order?
My lord, I'm coming, my lord. See me, the tender, I'm mentioning the tender. Your lordship kindly, on that day, my lord, honestly speaking, I could not argue the matter, my lord. That this thing has been happened. Page 27, my lord. Have you lordship got it? Agree field cares. Number of kit has been mentioned, my lord. And the amount has been fixed 843 32137.
Yes.
Signature of managing the Assam Seed Corporation is available, my lord. General manager signature is available. Accordingly, my lord. And if you also go to the tender number, my lord, page number 25, my lord.
And this is the intent.
Yes, my lord. I'm coming back. The same tender number is important, my lord. You are floated e-tender number so and so 395209, which has been duly submitted by. Accordingly,
Page 25.
page 25,
Which one? Which one?
second paragraph.
Yes.
Yes, my lord. And my lord, accordingly, bill has been given. And here your lordship will got the signature of all person. District Agriculture Officer, page 38, my lord.
Heard Mr. N.N.V. Chaudhary, Learned Counsel for a petition. Z. Bora. Learned Standing Counsel, Agriculture Department, for the response number 1, 3, 6, 7. Miss A. Bothagur, Learned Counsel, on behalf of Mr. P. Nayak, Learned Standing Counsel, Finance Department, for the response number 2. Posto. The petitioner stated that in response to an tender.
May I think, my lord, important thing, my lord.
The issue notice
Sorry, my lord.
dated 5/2/2019. The petitioner submitted his bid, having emerged successful in the bidding process, a supply order dated 25/11/2020 was issued in favor of the petitioner in terms of the terms and conditions of the e-tender notice, along with the supply order, by the supply order, the petitioner was directed to supply hybrid vegetable seeds as per specification mentioned in Annexer 1 and Annexer 2 to the supply order within 31/12/2020. So stop. The petitioner has claimed that the petitioner had supplied the ordered seats within due time and the delivery was duly acknowledged by the responding authorities in the Assam Seeds Corporation Limited. Full stop. As the bill amount submitted for rupees 8,43,321.37 has not been released to the petitioner till date, despite repeated approaches and representations. The petitioner has instituted the instant petition seeking a direction to the responding authorities to release the said amount expeditiously. Post of issue notice returnable on so and so as Ms. Bora and Ms. Bothakur. The counsel for the petitioner shall furnish requisite number of copies of the petition along with annexure to Mr. S. Somoria Learned Standing Counsel, Assam Seeds Corporation Limited, for service of notice upon the respond number 4, 5, 8, and 9 within 2 working days from today.
My lord, I filed
It
an
is
edition.
observed that pendency of the petition shall not be a bar for the respondent authorities to examine and release the entitled amount to the petition.
I filed an additional affidavit, my lord. Actually, my lord, 3,97,95,987 has been paid
Okay.
out of 8 lakhs, my lord.
Well, then line লিখিব এই ডাইরেকশনের আগত ডাইরেকশন যে কৈছিলো in the subsequent period, out of the total bill amount of rupees so and so, the responding authorities
Has paid
paid
3,90,987.
post of Mr.
And now
Choudhury
pending
has
is-
submitted that the writ petition, the direction the writ petition is to be confined for an amount of rupees.
Paid, my lord, 3,97,98.
I have not done the calculation.
Done, everything has been done, man.
What is the then balance amount?
Balance amount is 4,50,334.
Tell that 4 lakh
50,334.
33
4.
4.
Yes, my lord.
No paisa.
No paisa.
27
down
April, 2704.
My lord, I have a prayer, my lord, small prayer. Because similar matter payment has been made and submission has been made by the government, fund has been come to this tender, my lord, for the period 2025-26, my lord. If 1 crore something, my lord. That is before that, my lord, if before 31st March, my lord. Your lordship, kindly go through the order, my lord. Same tender, my lord. And similar matter has been fixed on 23rd. Same petition. Tender has been same, if you will also go to the number.
Mr. Somoria is not available to pass any order to take instruction.
I shall inform to this homeowner.
Let us have their stand, otherwise it creates difficulties.
Only
Gives rise to contempt petition and all this.
Only 23rd other matter has been fixed, my lord. Same period, other matter has been fixed, my lord.
You want this to be fixed 23rd?
Yes, my lord.
This is what
Only. Most of bless.
This is the case on 23rd. As Mr. Somoria,
Supplemental notice.
Leonard Training Council,
40%.
Assam State Corporation is found and sent to the on-call. Release the case on 23/3/2026 for further consideration. Interest of balance amount. Interest of
Item
Yes,
4 is the same.
Item number 1, Lordship.
1 minute, let's. 4,
Same amount is only 15,21,000 outstanding. The
no
bill,
part payment,
yes, fella.
no part payment.
Part payment has been made. 28
1
lakhs.
minute, 1 minute, 1 minute.
I'm coming. Para 8. You look.
1 minute, 1 minute, 1 minute.
Para 8 is
Hybrid vegetable CD. Supply order 9/11/2020. Oh no, not 9/11/2020. Not 9/11. But 23/11/2020. Tender notice to same, e-tender notice same. Baki ki news same. Annexer 1 and 2 same. Then Baki ki news same, 28,49,587.40.
yes, fella.
Right?
Yes.
What is the part payment?
Payment made 13,27,908.
So remaining
Remaining 15,21,679.
same, 23rd. Yes, Mr. Song.
Item number 1, Lordship, what is some instruction?
Yes, you were in a repetition. That is why.
This regarding this tender matter, Lordship, my instructions that I have, though for the first time it has come, but I have my instructions. There, after this court order, the authority had constituted a new technical committee for evaluating the tender process. Pursuant to that, that particular committee had evaluated all the tenders and have found everyone to be disqualified. There is
Well,
not.
But
and now-
that has not been conveyed to us.
No.
1 minute, sir.
Because they wanted me to answer, so I have the information.
1 minute, let him answer.
So pursuant to them, everyone been found to be technically not suitable. The authorities have decided to go for a retender.
Just a minute, just a minute.
This is from my personal knowledge, I'm saying.
Just a minute.
Please give me-
So, third direction is that to
Yes, express.
appraise, evaluate the technical bids of all the evidence.
So for that, what has been done is earlier.
So do you have the decision? Otherwise, you will issue notice, returnable 4 weeks. No point.
This order has otherwise been complied.
So
Maybe not to his- Not to his liking. but
can you have it?
Not today, right now.
No, not today. On the
Yeah.
next week, next week.
Monday, they are getting-
Otherwise, no point giving it, issuing notice after that 6 months, the result is same.
Well, the procedure is you reject me, fine. You accept, fine. But you have to upload it on the e-portal. Have they done it? Have they complied with the mandatory procedure laid down in the Assam procurement rules?
I'll take instruction.
Neither has it been conveyed nor has it been
I can
uploaded.
say, because I've seen the.
Now, he is a standing counsel, he is asking, I have asked. The court has
Let him produce it,
requested, the
Mallet.
court has requested him to assist the court. So let him take instruction. Otherwise, I can issue notice, returnable 4 weeks.
No, Mallet.
Any purpose will be served. No purpose. They will come
Because
and
I
say,
have seen that order regarding the disqualification
Okay.
of all and the proposal to go for a press.
I heard Mr. P.K. Hendy, right? Learned counsel for the petitioner. This contempt petition is preferred. Alleging non-compliance of the directions made in a judgment and order dated 19/12/2025, passed what is your repetition? Passed in a repetition. WPC number. Both are yours.
Both mine.
Yes.
Both are yours.
Malad.
In a common judgment. In a common judgment and order dated 19/12/2025, passed in two writ petitions, WBC number 7076/2025 and WBC number 6542/2025, preferred by the petitioner. First of, it is stated that it is averred that the copy of the judgment dated so and so was duly brought to the knowledge of the respondents, post of para, as the concerned respondents are from the Assam, are officials of the Assam Plain Tribes Development Corporation Limited, Mr. Angshuman A. Sharma, Land Standing Council, APTDCL, is requested to obtain instruction as to whether subsequent pursuant to the judgment and order dated so and so, the respondent AP so and so authorities had carried out the direction or not. Post of Mr. Sharma has sought time till Wednesday to obtain instructions in the matter and to place the decision, if any, of the respondent AP so and so the authorities.
Well, if my lord, I may also direct them, if any decision has been taken, let it be uploaded on the e-portal so that it is known to everybody.
We are into content. Mr. Hendik, we are into content. Let us see first whether decision has been
Large
taken.
lordship.
That is not the direction in the.
Yes.
I'll be
If you
beyond.
agree by that, file a repetition.
The evaluation has been done, then I can say today.
18-3.
Only that my name can be shown for the.
Under the name of Mr. A. Sharma, Land Standing Council, so and so, be reflected in the respondent side in the call list.
Okay.
You need
Item
any
6.
copy?
What's that?
You need any copy?
I think I have already been given a copy by him.
Good.
I'll take this.
Maybe the lordship. Last occasion, my lord, your lordship, my lord, put a question that the area of operation concept has already, my lord,
Some cooperative society.
gone, my lord. So after, my lord, National Food Security Act, my lord, the government of Assam came up with a decision.
Notification. Just a minute. Secretary Corporation issued to, that is, you refer to some 2010. That is why
Yes, my lord.
with direction to convey prior approval of the governor of Assam regarding formation of new ZPSS co-terminus with the existing Gaon Panchayat. And your society got registered in 2011.
Yes, ma'am.
Then you sought for area of operation Bandol Kuna Gaon Panchayat.
Yes.
And also a PDS license.
Yes.
Right?
Yes. And earlier also filed.
But that concept comes from Assam Cooperative Societies Act. Area of operation.
My lord.
Is it not?
My lord.
Then Section 6 perhaps of the Assam Cooperative Societies Act.
Condition of registration.
Assam Cooperative Societies Act.
Yes.
Conditions of registration.
My
lord. No society.
Yes.
Do you have the copy?
Yes, ma'am.
Read.
No society other than a society of which a member is a registered society shall be registered under this act, which does not consist of at least such number of eligible persons as may be prescribed by the Register of Cooperative Societies, provided that the number of members for the above purpose shall not in any case be less than 10 members competent to contract under Section 11.
So this is condition for registration.
My lord.
Next. Subsection 2.
Yes. The word limited shall be at least limit shall be the last word in the name of every society registered under this act.
3.
Provided that
No, the 3, subsection 3.
3 is not there, my lord. In the deleted, my lord.
That is what? Earlier was no society shall be registered under the Assam Cooperative Societies Act in an area where there exists another cooperative society with similar objective.
Right.
Provided that registrar may allow registration of more than one cooperative society in the same area of operation in case the need or necessity demand for organization of such type of societies require registration of more than such type of societies in the same area of operation. However, in doing so, proper justification. Now that has been deleted. There is no area of operation concept. If you see old GLRs and GLTs, many cases are fought on area of operation. Nowadays, no area of operation. So, GPSS that your society
Yes.
should be within the GPSS
GPSS area. That is-
area of operation. When the area of operation, its concept is gone,
Minor.
how does that plea will be sustainable? How does that plea is sustainable? That is what my query is. My query is that
Yes, that is, yeah, my lord.
you have referred to some 2010.
Yes, but this act was.
We are in 2026.
But this act of 2020, 2007, my lord. After that, my society was registered, my lord.
Right. And that amendment carried out when? Deleted when? In 2022. Subsection 3. See below?
Yes.
See.
22, my lord. 1st February 2022.
Let us have your book.
Yes, in the below that is there, my lord.
No, I have this book, but that amendment. আছে এখন কেতিয়া পুৰণি এখন মস্ত পুৰণি আৰু পুৰণি এইখন এইখন কি কোন চনৰ এইখন 2023 25 এখন এইবোৰ পুৰণি এইবোৰ গ'ল এইবোৰ ৰ'ব This is again wrong. If the subsection 3 goes,
My lord.
this printing is wrong. If subsection 3 goes,
My lord.
proviso cannot remain. This
That is there.
printing is wrong. Who has done it? Again, there will be confusion. Who is the author?
To see, my lord.
No author, no responsibility, no accountability. No author. No author.
Without.
See, is there any author? This one was Mr. R.C. Soikya, but that is by the publisher himself.
Assam Law House.
Yes, Mr. Das, if the section, show the book to him. That area of operation concept earlier. Now, C6, section 6.
Yes, prohibitions of registration.
Subsection 1 is there.
Yes.
Subsection 2 is there. Subsection 3
Deleted.
deleted.
Yes.
Then there is a proviso.
Yes.
Now give this amendment to me. If the proviso to a particular subsection, can it stand alone? Right.
This is 1st of April 2022. Deleted.
And see this one. This book is prior to the amendment, right?
Yes.
Then thereafter amendment came,
Yes.
and thereafter this new book came. See the proviso, section 6, subsection 3. It was there,
No, it was.
and proviso was tagged with subsection 3. Right?
So without that section. There has to be a section.
Whether if the head is gone,
Yes. So
whether the rest of the body can live, survive.
done, I don't know. I was also shocked.
There is no author.
What?
So no accountability, no responsibility. And everybody will be misguided by.
But there has to be a section, then thereafter proviso comes. The proviso cannot stand alone without the.
If the head goes, then how the body can survive? I don't know.
This cannot be, with great respect, this book cannot be relied. No, you
Already.
forget about all this. When you insert a proviso, there has to be a section. Then proviso.
And proviso is as an exception to
Yes.
subsection 3.
Yes.
Right?
Yes.
Then every cooperative society should have a area of operation.
Yes.
However, by the proviso, registrar can have 2 societies within the same area of operation.
Yes.
Now, the main substantive provision is gone.
Yes.
Now, subsection proviso survives
Yes.
as per the said book.
Yes.
But I don't think that is right.
That's also may not be right.
So, you are relying on 2010. Amendment রাখি দেবো, পুরোনো কিতাব। So, how do you substantiate your case? How do you substantiate your case? আমার পুরনো কিতাব কোন
এইটো কোটৰ
হ্যাঁ এখন নালাগে মোক নোট এইখন আমার So how do you substantiate your case? That is a query of the court. Yes, thank you, Mr.
Respectful submission is that if this goes on, it will be very difficult in a judicial proceeding.
Yes.
So something has to be reflected. This is my.
This is also strange. The new editions does not carry any name of the author.
Yes.
Simply the publisher has
Yes.
published it. This is not the way.
Yes.
এখন কিতাব আমার লাইব্রেরি না লাগে দেই
Your lordship has gone into details, but there are.
No, it's
With
certainly.
respect, with great respect. There's sometimes we also overlook, but your lordship. has
No,
gone to it.
I
The
knew that
proviso-
subsection 3 is gone. I
Yes.
knew. So that is why when he gave this book to me, so it occurred in my mind how the proviso survive.
Yes.
Take it over your case.
my lord. After 2
Make
weeks,
some more research.
Find it out also.
yes, I will
This
also,
book is-
yes, my lord, I will also find out. After 2
Find
weeks,
it out how to substantiate your case. That concept is gone,
my lord.
on which you are relying.
Yes.
Okay, on the prayer of Mr. H.R. Ahmed, learned counsel for the petitioner, place the case again on so and so.
Otherwise, that system.
Do you have anything to say?
No, apart from that aspect, lordship, the system of gifting and distributing PTS. Now the system has changed. There is some tender process. In the writ petition, it is not reflected whether they have participated in any kind of tender process. or-
TPDS is tender process now.
Yes, yes. Because
That is transportation.
yes.
That is transportation.
Yes, yes, it has been.
That is by tender process. But so far as allotment is concerned, perhaps you have to have a license under the proper control order like say PDA order, or there is another PDS nowadays, TPDS order, something like that. That the society has to have that license.
That is correct.
That is not by tender process perhaps.
Oh, yes, yes.
And that is what they want. On the ground that our area of operation is this panchayat. That concept is gone. List the case on sir. Mr. S.R. Boruwal and Junior Government Advocate for the respondent. Where is Register of Cooperative Societies? He can highlight. Yes, madam. Please.
My book, I'm holding there.
Which book? This book?
Yes.
Throw it away. Miss 1, 3, 4, 5, and Miss Andy Bora, Learned Standing Council, Register Corporation Departments for the respondent number 2 and 6 are present. First of the Learned Council for the official respondents are to obtain instruction whether the area of operation of a registered cooperative society under the Assam Cooperative Societies Act 2007 as amended can be made related to the territorial jurisdiction of a Gaon Panchayat. Release the case on sense.
Obliged, madam. 2703. Item 7.
May please your lordship. My learned friend was to bring instruction, my lord. The impugn order is at page 40. Your lordship, I like to peruse your lordship's earlier order. Dated 25 to 2000 pages. Basic instruction.
Yes.
Exactly.
According to petitioner, that government act number 75, 159 and 161 are part of the fisheries. They are settled with. So obviously it is government land, since it is, I think, 60% category fishery. Obviously it is government land. So if that is these act numbers are part of the fisheries and they are the settlement holders. Maybe correctly 75 may have a bigger areas. Fishery may be a part of it.
My lord.
That is why you have not been served with notice also. That could be the case also.
That could be.
Only that clarification, why notice, reply, all this will take time. Yes, mister. You are sitting tight. You are the main man.
Yeah. 60% fishery.
Obviously it will be government land.
The commissioner initially lordship, I forgot the rule lordship. As per fishery rules, they are transferred to us. So now the government cannot acquire the land, acquire the fishery.
No, fishery department is not separate from government, sir.
No,
And the character of the land will not change.
character of the land.
It will be government dog.
Then also government dog, but it will be under fishery.
It will be recorded in the Cheetah and Revenue record as pond. or fishery? By what name it will be changed? Tell me. Fishery will do. It is for AFDC. Don't. Section A, Rule 8. Not for 60% or 40%. Where is that fishery settlement? You said about that? That it is part of your fishery.
Settlement order is at page 22,
That is settlement order,
my lord.
but area of the fishery, anything you mentioned?
Page 29, your lordship will get that, my lord, while handing over possession.
Huh.
Two lots. Register of fisheries.
It will be registered,
Yes.
but character of as government land will not change. It will be registered in a register of fishery, Rule 2.
Registered as a group.
Come to page 30.
I can swear.
Heard Mr. M.K. Choudhury, Learned Senior Counsel, stated by Mr. S. Kaun, Learned Counsel for the petitioner. Mr. S.R. Burwal, Learned Junior Government Advocate, Assam for the respondent number 1, 4, and 5. Ms. C.A. Learned Counsel on behalf of Ms. M. P. Chakraborty, Learned Standing Counsel, Water Resources Department for the respondent number 3, and Mr. P. Sharma, Learned Standing Counsel. This is AFDC fishery.
My lord,
Fishery.
fishery department,
Fishery Department.
government.
Standing Counsel. Fishery Department. Okay. This P. Sharma, Standing Counsel, Fishery Department for the respondent number 1 and 2. First of all. Para. Now, Mr. Borua has submitted that he is yet to receive the necessary instruction. First of all. Para. To be more specific, para. As per the when the fishery number 38 Morihuti Mean Mahal was possession of the fishery was handed over to the petitioner society as the settlement holder on 16/9/2021 by the Circle Officer, Mayong Revenue Circle, within bracket the respondent number 5. It was clearly mentioned that the fishery comprised of lands, parcels of land falling, fishery, having an area of 202 bigha, 1 kotha 10 lesa, comprised of parcels of land falling within DAG number 75, 159, and 161. First off. The apart from the query raised, apart from the issues mentioned, issue mentioned in the previous order dated 25/2/2026. The learned counsel for the respondent number 1, 2, 4 and 5 shall obtain instruction as to the as regards the total area. This notice is for doc number 75.
My lord, this notice, impugn notice, my lord. Those are, my lord, many ducks. These 3 ducks are also included.
All 3 ducts.
Yes, my lord. Page 40, my lord.
Page
Page 40.
what are the total areas in each of the respective doc number 75, 159 and 161. Full stop. Further, comma, the said respondent shall provide instruction out of the total areas of each doc number. How much areas are earmarked for 38 number. Morihuti mean Mohol. Firstly, secondly, and thirdly. Whether any notice under Rule 18 of the Assam land of the settlement rules has been issued or is contemplated to the petitioner society as the settlement holder of number 38 Morihuti Mean Mahal. Total lag number area?
Yes.
How much is earmarked for fishery
fishery?
out of each respective lag number? And whether any notice has been issued or is contemplated to the petitioner society as the settlement holder? These 3 queries, I think.
That will satisfy me.
The apprehension will be misplaced till the earlier interim order that no coercive action against the petitioner society shall be taken on the basis of any notice under Rule 18 of the settlement rules shall continue till the next database.
Highly obliged.
And Mr. Don't delay. No 2 weeks. Then you will say, oh, election.
3003. 3003.
This Friday, next Friday,
Next Friday.
place the case on 20
20.
to enable the learners of counsel for the official respondents to place the instructions without fail.
Item number 9.
Mr. Count, please hand it over.
How many?
And a copy of this order is to be supplied to, I am supplying so that you don't fail, Mr. Sharma and Mr. Borua, so as to take necessary steps from their ends.
Item 9.
This one, remove the arson and photo. Yes, please take one note, my lord. I may note. Today, my lord, I'll argue in a very narrow campus, my lord. I'll tell what is about the case, my lord. Please take this note, my lord. Earlier, I came before this court. What report, sir? WPC 1155 of 2026. I think this one again. Into base. Please see that, my lord, first the order which was we came before this court.
Page
361.
This is 361.
Okay, Liberty.
Liberty.
Subsequent development.
Subsequent development, because we came to the court, work order was not been issued. Thereafter, they decided on a Sunday. This was on Friday, when a matter was to be moved, but somehow it could not be moved. But they decided to cancel on a Sunday. But that subsequent development has taken place. That's why we took a liberty, and accordingly, we have before this on my court, my lord. Now, my lord will kindly see at page 29. This is the NIT, and the work is contract for construction of drill site, approach road, internal hardening, and other ancillary civil work. Now, if your lordship, please turn to page 30. Next page. This is a single bid system. And period of contract is 2 years. Now, please turn to page 32, my lord. This is an instruction to bidders. Now, page 99, please see, my lord. Bid evaluation criteria. Technical 99. This is your lordship will find rejection criteria, technical rejection criteria. The following vital technical conditions would be strictly complied when the bid will be rejected. Eligibility and experience of bidder. Please see now down below C. Supporting document as proof of experience should be notary attested true copies. This is the case which this petitioner, my lord, they have supporting documents, but it was not notarized. That was the case, my lord. And the price bid at page 102, please look into it, 102, price bid evolution criteria. Now, please see 103, my lord. This is how it has to be evaluated. ONC shall evaluate the third paragraph. ONC shall evaluate inter se ranking the bidders and conduct draw of lots among the eligible bidder in case of identical prices, and contracts shall be awarded accordingly. So here is a case where my lord identical prices was given. So everybody quoted the identical prices. Now the lowest. When it is lowest, then it will be a draw of lots. Now draw of lots, my lord, if your lordship kindly see, if the bid of the bidder B1 is found to be technically and commercially qualified, B1 will be successful bidder, priority 1 bidder. And the contract will be awarded to B1. If B1 is not found to be technically and commercially qualified and B2 is technically and commercially qualified, B2 will be awarded.
Come to page third paragraph.
Third paragraph, my lord.
Bid will be opened on scheduled date.
Yes.
And time as specified in the NIT.
Yes.
And all the bids where the bidders have quoted the lowest price.
Yes.
Within the permissible limit percentage as per will be selected for conducting draw lots.
Correct.
Draw lots will be conducted on bid closing date. In the DOL, 7 number of bidders will be selected first. In the order of B1, B2, B3, so and so.
Yes.
The technical and commercial scrutiny will be carried out for these 7 bidders only.
Yes.
If the bid of the bidder B1 is found to be technically and commercially qualified, B1 will be successful bidder.
Yeah.
Priority 1 bidder, and the contract will be awarded to B1. If B1 is not found to be technically and commercially qualified, B2 is technically and commercially, B2 will be awarded. Like that. It will go on.
Yes, correct.
So it is a matter of chance.
Yes. I was very lucky. I was B1.
B1.
I was B1.
Where is that technological?
Yes.
Where is that list? B1.
327, man. 327. This 327.
327.
Lordship got it?
327.
This is yes.
Oh, please.
Please see this. B1 is probation.
This is in reference to
Reference so and so
was open.
on 39/2025.
Criteria. So all quoted the same price.
Same price. No,
So
Right.
by matter of chance and
I
lottery, you got B1.
B1.
So
But my-
you have got the chance to get your tender scrutinized first.
Correct, right.
Right.
Now, it is
If
not
you are found to be non-responsive, out.
out, even if
Then
B1.
they will go for B2.
B2, correct. That's the procedure, my lord. That's the procedure.
Okay, your name
Now-
emerges at
One,
B1.
B1.
Huh.
Probesh Burman.
Outcome.
Yes,
Now, later, as per BEC, if the bid is found to be technically and commercially qualified, we will be successful bidder. So it is a construction work
yes. Real site.
and contract will be awarded to B1. If the B is found to be so and so. Yes.
Now, there is the problem, single bid system. Not a technical bid, there are the financial bid.
No,
Now,
here-
what they found,
They have set up their own criteria. They will see price bid.
yes,
Because it's a rate contract.
yes, right,
Rate
Now-
contract.
yes.
So if 100,
yes,
there is also a lower limit
Yes.
perhaps.
Yes, correct.
Everybody
right.
quoted it. So
Correct.
it is rate contract.
Rate.
So all are equal.
Equal.
Now you have to find out
Yes,
the first among equal.
right.
And that is by lottery.
Draw.
You turned up to be the luckiest one.
Yes, lucky.
That your tender will be scrutinized first.
Correct. Absolutely right.
Right?
Right.
Then technically responsive or non-responsive.
Yes. Now they found that technically that BE1, which is a clause.
Now let us see the result.
Yes.
Thereafter, what is the next stage?
Yes.
They again reiterated.
Yes.
After the list,
Now-
T27,
Yes.
they said that how they are going
Yes.
to carry.
Now please see on what ground I have been rejected. That your lordship wants to know. Thereafter,
Yes.
what happened?
Yes.
Please 333.
333.
No, my lord, for a moment, if your lordship is not inconvenient, when this was passed on 39/2025,
Which
this
one?
date of minus of 327. It
Yes.
is what 39/2025, when minutes of draw at page 327.
339.
327, my lord, when your lordship has read
39. Oh.
39, lordship got it? 39/2025. The second, bids were open on scheduled date, that is 39/2025. Lordship got it? At page 327. Second paragraph, according bids were open on scheduled date, that is 39/2025, 15 hours onward. Now, they waited. When they waited, my lord, up to kindly see at page 332, I made an email to them, 332. Please see 332, my lord. This is, my email is 29th of January on the top. 29, I have have written to them. This is what rate of so and so in the bid validity period is already expired. However, the outcome of neither has been communicated to us nor uploaded the e-tender portal so far. Lordship got it, my lord? That is page 332. Now, thereafter, at page 333, on the next date, 30th of January, referring to above, you are informed that your so-and-so has been technically rejected duly approved by competent as the document submitted by you were not notary, attested true copy as so-and-so in the line with note C of B.1.2 of BEC. Now, please see, my lord.
That I
what-
have seen. Now, what is the next? What happened?
Now, yes. Next, my lord, there is a provision for representation at page 51, kindly see. Once it is rejected, then page 51. See page 51. In the NIT itself, please see 51, clause 38.1. Bidder can submit between any connection processing of tender, including rejection for rejection of bid. Lots of got it. Now, immediately on 30th of January 2026, I represented at 335. 335.
Yes.
Now, this representation
was in detail, 335. Please look into it, my lord. My lord, if your lord.
What is your answer to that query, B.1?
Yes, I answered this, my lord. 336, my lord. In the top, salient facts and procedural inconsistency. Lordship got it? We submitted a technical and commercial compliant bid. A qualified bidder quoted same price leading. Our bid was drawn first and declared B1 bidder. The signifies a formal selection of so and so. Only deviation cited post-selection submission of TPI verified true copies of experience and instead of notary attested copy. The authenticity and content of these documents are not in dispute. Further, the very same experience document have already been verified by ONC enlisted third-party inspection, Aditya Inspection and Services Private Limited. On the basis of this document, ONGC itself has accepted the undersigned as techno-commercial qualified in a similar tender bearing tender number for the work title annual rate contract for construction of various drill site and other civil works for exploratory and development location at Jorat asset for 3 years. This clearly establishes that there can be no doubt whatsoever regarding the authenticity or credibility of submitting documents which have already been verified.
Right, these are in line with
Yes.
experience already historical document.
Yes. Now, now, my lord, their reply, please see at page 341. 341. They said, with reference to your repentant submitted against the subject tender, hereby acknowledge the receipt of your repentation. The same is under examination and a detailed reply shall be communicated to you shortly. Now, this is of 16th of February 2026, my lord.
Yes.
Now, what they have done, without informing, they cancel, my lord, at 356. Kindly see, my lord.
356.
Yes. On 1-3.
Perhaps better for you.
I'm sorry.
Perhaps better for you.
1-3 to have without informing. They should have at least informed me and they take a decision. No problem.
Perhaps better for you.
They didn't inform.
You have got another opportunity.
First opportunity, my lord, I came to this
Lucky.
court. I came to this
You
court.
became very lucky.
Who out?
At least among 8. Maybe there are more. I don't know. But they said we'll shortlist 7 or 8.
Correct. My lord, in absence, I have seen other also the case also. In absence of any of a minor, it is not been spelled out. If
that Rosmi Metallic and Poddar is gone.
My lord, whether
Rosmi Metallic Poddar is gone.
yes, now that is I am not relying. What I am saying that if that particular is not been spelled out in terms and condition on a bid document, then how it will be looked into it if there is there are some contract where minor deviation can be waived. Now whether my lord they follow
So far as
CBC
interim
guidelines.
order is concerned, I don't think it is.
No, I
for
don't
interim
want.
order.
No,
We
no,
can
what
only
I-
issue notice.
No, notice plus they will not go ahead with any of the tender process, my lord. What will happen?
Then I have
suppose-
to
No,
assign
suppose-
regions.
No, suppose tomorrow your lordship finds. Suppose, my lord, I don't know.
It is not that by you became L1. You, along with many, became L1.
Yes,
And out of that, you came out to be lucky.
yes,
Then there are scrutiny.
yes.
Because it is not that there are other incompetent
No, that's correct. That's your
persons in
lordship
a
side. That is the same when your lordship's view. That is also when I said that was my view. But what has been done, there is a CBC guidelines. Which,
CBC, it will go by the terms.
no, they have
and
agreed.
conditions.
They have agreed. ONC
And also,
himself agreed.
CBC is only guidelines.
No, please see, my lord, at 344, if your lordship will kindly see, your lordship is right. It is a guidelines. It is a guideline. It is not true some of that has to be mandated
Many
by
decisions
some of the
have come in
statute.
line now.
No, there are certain judgment, certain statute which is mandated by a statute, these guidelines. Drugs and cosmetic is mandated by guidelines. But 344, kindly see, my lord. They have adopted. That's what I am saying, my lord. Kindly see, this is a circular, so and so. What you got it at 344? 344, my lord. 344. This is the updation of manual of procurement goods, services, central business income which guidelines on so and so. Now please see at 349, my lord. 349. 349.
Let us first understand.
Yes, ma'am.
You are challenging the rejection of your technical bid, or you are challenging the order of cancellation of the
I am
process?
number one. I am challenging the cancellation order because only the ground is that there is a provision at page 51 where it says that any rejection of a tender, a bidder has got right to represent the matter before the authority. And the representation has to be disposed of by them. What is then done in this case? When I file a representation again by rejection, which is provided on a terms and condition of bid document, and they said on 16th of February 2026 that we will reply. They should have given a reply. So where is the question, my lord, passing of impugn order without giving reply? That's my case, my lord. That is my case, my lord. Please look into it, page 356, kindly, my lord. My lord, this is, my lord, and kindly see, my lord, that will, of course, your lordship will examine on second part, whether technically this, because your lordship is absolutely correct. Is B1, then automatically B2, then B3, B4, B5. I was lucky that on lot.
You are lucky
my,
only.
My only grievance here is, my only grievance.
If they go by strictness, then
Correct.
strictness.
My lord, then what happened? Your lordship is absolutely correct. If B1, strictly they go, then the offer will go to B2.
Sure.
If offer go to B2, then B3.
That is why
B4.
I said.
No, that's what I have looked into it and your lordship is right. First,
That is why I said
Yes.
this impugn cancellation order perhaps
My lord,
made you lucky.
no, what I am
Whether in the next process you will turn out to be lucky or not, that is
that's different. No, what I was on here, what I was on and I came to this honorable court is my only grievance. Is forget for a moment about my job. My is only grievance is that there is a provision where you have given, once the bid is rejected, there is a provision for representation. This is apparently I have shown to your lordship at page 51. They said on 16th of February, I will give a reply to your representation.
right.
Then on 356, without giving a reply, they have
If
rejected.
the whole process is cancelled, then what is the reply?
No, they have, because there is a provision, my lord. There is a
Right.
provision.
But if the whole process, then the competent authority also has the power to cancel the entire process.
No, my lord.
Without assigning perhaps any region.
No, my lord.
Then this becomes redundant.
Then why that 51 that clause is given, my lord?
Yes, that is there.
51.
Also, there
Then
might be
there is
other clauses, Mr. Das,
Yes.
that without assigning any region,
There
the
is a
competent
clause.
authority can cancel the entire process.
My lord,
and
your-
law is also that
Your lordship.
this is administrative order without regioning, without
lord-
assigning any region, it can be cancelled,
My lord-
and region can come in the form of affidavit.
Correct. But reason can be on a part of a record
Latest
before
one,
this
old one. all
record
keep-
before the court. But there is one judgment of the Supreme Court in 2024. There is a big judgment that whenever is cancelled, then, my lord, the situation now has changed. There has to be some reasons to be given to communicate. I'll just show the judgment, my lord. My
Then
case is that your lordship,
I have 7 at least.
yes.
And
My
regarding
lord,
that, no region is to be
My
assigned.
lord, I have seen, my lord, there are cases, my lord, where record is produced before the court. It is enough. It is enough. My only grievance here, that forget the merit of the case, I am saying that why I have not been represented. My reply has not been given to me.
Who is the provision for cancelling
Yes.
the entire process?
Yes. There is a provision without any reason, quote say to. Yes. Page 33, kindly see, my lord. It is rejection. With tender rejection without any reasons.
Page 30B,
30B. I am deeply obliged.
serial number 34.
I am deeply obliged, my lord. Yes. Reserve the right to reject so and so.
Cancel or withdraw the
Yes,
invitation
yes,
to bid without
33.
assigning any region
Yes.
whatsoever. In such cases, no bidder, intending bidder shall have any claim arising out of such actions. So that is why it was not
But only one.
answered.
My lord. But the then become 51, if your lordship looks into it. 51, there is a provision.
Right, but
There is a provision.
I am
No,
not-
no, I'm just placing it, my lord. Your lordship will take a call.
we can issue notice,
I
but
will-
at this stage,
That will
no
be
stalling.
subject to further order of this court. Let them come, subject to further order of this court.
Because
I
they are
also know.
obliged to give region, to
Yes.
have regions, but by cancelling it, they may not assign region, but they are obliged to give regions in the affidavit.
They are 100%, my lord. There are
Right,
cases.
but otherwise, it is not that they do not
No,
have
no,
to.
no, it's not that. What I am placing, your lordship is right. Only I am placing because there is a clause. That's the reason I am placing it before the court. Your lordship will absolutely take a call. Only I place it because of the clause of 38.1. Only what can be done, my lord, if you are subject to your lordship.
At least I know the predicament of the petitioner. At least I can appreciate the predicament of the petitioner, despite emerging B1, just because small mistake.
Now, by that mistake, I have, my lord, forgive me.
Whether it is curable or not curable, we are
No,
not
your
commenting.
lordship is-
Heard
Please,
Mr.
yes.
D. Das, Senior Counsel, yesterday by Mr. K. Mohammed, Learned Counsel for the petitioner. Mr. Roy, you are there. And Mr. S. Roy, Learned Central Government Counsel for the respondent number 1, full stop. The respondent who Oil and Natural Gas Corporation Limited. Corporation, we didn't make it ONC. Invited, published a notice inviting tenders, we didn't make it NIT. On national competitive basis under single bid system through e-procurement system for a contract for quote unquote case 30, rate contract for construction of drill site, approach road, internal hardening, and other ancillary civil works of AAFB dash forward base, ONGC Silchar, Assam, unquote. And the estimated cost put to tender was rupees 9 crore 17 lakh. In Annex 4. With the award criteria,
I'm sorry, my lord.
award that clause
Draw of lot is as page 327, my lord.
327. No, in the main document also it is there, perhaps. Bidding document.
Yes, go ahead. Yes, yes. It is, my lord, will at page 103, my lord.
103.
How it has to be done?
Ah.
103.
Right.
103. At page 102, price bid evaluation criteria. Down below, price bid evaluation criteria.
Page 102. The evaluation criteria for evaluation of the bids of the participant bidders are laid down in the following manner in the bidding document, page 103. But it is the case of the petitioner that after submission of bids, drop lots, as there were more than one bidders who had quoted the lowest identical price in e-tender portal, a drop lots was carried out on 39/2025 after opening of the price bids. First of in the drop lots conducted on 39/2025 itself, a priority list of 10 bidders who had quoted the lowest identical price was prepared and published, wherein the petitioner published as B1 to B10, wherein the petitioner emerged as B1 bidder whose bid is to be scrutinized, whose technical and commercial bid is to be scrutinized first, that is ahead of B2 to B9. Full stop. When the declaration of the successful bidder was not published for a reasonable period of time, the petitioner made a representation before the correspondent ONGC authorities on 29/1/2026. First off, in response to the said representation, the petitioner was informed by a reply mail on 30/01/2026, stating that bid of the petitioner, the technical bid of the petitioner had been rejected as the documents submitted by the petitioner were not notary attested true copies, as required in line with note within bracket C of clause B.1.2 of the bid evaluation criteria BEC. Full stop. On being informed about the rejection of the technical bid, the petitioner made a representation before the competent authority on detailed representation, 31/2026, highlighting the reasons as to why the petitioner's technical bid should not have been rejected, and there ought to have been a reasonable approach to by the grant of an opportunity to regularize the minor procedural lapse. Full stop. When the said representation was stated to be under examination of the competent authority, all on a sudden, a decision was conveyed as a corrigendum to tender. On which date?
Which the 16th of February 2020.
16 to 2026.
Then we filed
Whereby
my-
the entire tender process is said to be cancelled due to administrative reasons. Post of para Mr. Das, Senior Counsel, PM for a petitioner referring to page 51.
Cancellation is 1/3/2000, my lord.
Okay,
Cancellation is 1/3. Thereafter, we file repetition
1/3/2000.
after
Well,
16
as referred to clause 38.0, quote unquote, representation from bidder of the bidding document to submit that the bidder had a right to submit a representation in connection with the processing of the tender, including seeking the reasons for rejection of their bids. And in case such a representation is filed, the competent authority is obligated to consider such representation and pass an order, region order. In the case in hand, before passing a region order on the representation submitted by the petitioner, the tender process initiated by the NIT for the contract work has been cancelled, which according to him is arbitrary and unjustified. He has further referred to the circular of the Central Vigilance Commission.
which is relied by ONC, ma'am.
Central Vigilance Commission
Which is adopted by ONC
Ah.
349.
regarding the manner in which minor procedural defect can be cured, and the guidelines of the Central Vigilance Commission have also been adopted by the respondent ONGC Limited. In such view of the matter, the rejection of the petitioner's technical bid as well as the cancellation of the entire process is arbitrary and illegal. Matter would require consideration. Issue notice, returnable on so and so, as Mr. Roy, CGC, for 1. Petition shall take steps for service of notice. 2 to 5 to 4 speed post, 2 working days. Yes. Shall I?
Subject to further order of this court. Next interim,
Okay.
my lord.
The prayer for interim relief
Will be
is kept
considered.
open for consideration on the returnable.
Subject to further order of this.
We don't know if suppose they don't need, suppose this, what they say, construction of drill site. End of the matter.
That's the end of the matter. If it doesn't need, then it's a different.
The end of the matter, we don't know.
We don't, well, that's why I'm saying that can be considered on the exit also, subject to further order of this court.
Your prayer for interim release is kept open for consideration. That itself will do.
Some type of, my lord, subject to further orders.
Okay.
It's up to you.
The matter of rejection of the technical bid, matters of rejection of the technical bid of the petitioner and the cancellation of the tender process initiated by the NIT dated so and so are subject to further orders of this court.
2404.
Okay, ma'am. No problem.
Item number 10.
May I please your lordship? Lordship, petition for non-payment of bill.
Mr.
A Brahma lordship.
A.
Brahma.
Come to order petition. Mr. B. Chakraborty, Land Central Government Council, for all the respondents. First of the petitioner has stated that he had executed a contract worker. You know, Person to a contract agreement number so and so. After successfully executing the contract work, the petitioner submitted bills for it, bills. These bills, full stop, but an amount of rupees 20 lakh. 27,932 is yet to be disbursed to the petitioner by the respondent authorities. Issue notice returnable on so and so. As Mr. Chakraborty has appeared accepted notice on behalf of all the respondents, no formal notice, extra copies within 2 working days.
2704.
The respondents shall file their response on or before the return date.
Obliged counsel.
Item 11.
Yeah.
Mr. A.K. Hussain, counsel for the petitioner, and Mr. S.R. Bolwa, Junior Government Advocate, Assam, for all the respondents.
Except two.
Okay. Except two by the petitioner stated that he is the registered owner of a vehicle, Bolero, bearing registration number ES 31B 3152. Full stop. The subject vehicle was taken on hire from time to time by the respondent number 6 for deploying it in law and order duty, etc. Full stop. The petitioner, after the subject vehicle was released, submitted a bill for higher charges.
No, vehicle yet not released.
Huh?
It is still in the.
Okay. Okay, now I released them. I submitted a bill for the period from 18/5/2022 to 39/2025 for an amount of rupees 14,24,278. Full stop. Out of the said amount, only an amount of rupees 1,84,528 has been disbursed to the petitioner till date, with an amount of rupees 12,39,754 as outstanding till date, seeking a direction to the respondent authorities to release the remaining amount of rupees so and so. The petitioner has preferred the instant writ petition, issue notice, return so and so, as so and so, Ms. Watakur, on behalf of P. Nayak, standing counsel, respondent number 2, huh? Extra copies, 2 working days.
2704.
The respondent authorities will file their response on or before the return date.
2704.
27.
April. Item number 13. Item 13.
Lord, the petitioner has challenged a blacklisting order. Lordship, what has happened was the petitioner was executing a contract for transportation of LPG cylinders under IOCL. Under that contract, he had supplied 7 vehicles, 7 trucks. 2 of those trucks he had acquired from a third party, but later on he had transferred the registration in his name. The contract was being executed from 2024 onwards, Your Lordship. Suddenly, in November 2025, he receives a show cause notice from IOCL saying that the chassis numbers of these 2 trucks, I have falsified them. So he submits 2 replies, Your Lordship, one on 15/11/2025 and 12/12/2025. Sum and substance of the reply is that firstly, I have not falsified any of the details in the registration certificate. I have bought the vehicles from somebody. The registration has been transferred in my name. I have believed the particulars which are contained in the certificate. And secondly, as per the presumption under Section 79 of the Evidence Act, the contents of those of a certificate issued by a public authority, they have to be presumed to be true unless the contrary is proved. IOCL, your lordship, IOCL does not even consider the second reply. Only on the basis of the first reply, they say that it was your responsibility to verify from the manufacturer that whether the chassis numbers are correct or not. We have undertaken some inquiry with the manufacturer, and they have informed us that they do not have the records of this chassis number. Not that the chassis number does not exist or it is false. They do not have the records. Firstly, your lordship, as per Gorkha Security Services, it was their mandate to provide those records to me at the time of issuance of the show cause notice. That was not done, firstly. Secondly, your lordship, as per Kulja Industries, there was a right to a hearing, your lordship, when they are contemplating blacklisting, because that's what the Supreme Court has laid down. That was not done. Thirdly, your lordship, the legal issue is, once under Rule 44 of the Central Motor Vehicles Rules 89, after examining the documents, the registering authority has issued the certificate, and I have believed the contents of that certificate. I have submitted it before the authorities. The authorities are not now, even now, they are not saying that the certificate is wrong. They are saying the OEM does not have the records of the chassis number. Now, does the blame, your lordship, fall on me, your lordship, for that? If I may
Okay,
take your
then you
lordship,
submitted, then what is the impugn order?
so the impugn order, they have
Page?
it is at page number 228. They put me on holiday list for 2 years, your lordship.
Yes, Mr. Borua. You are in a position to submit your affidavit within 1 week.
My lord, I'm submitting my affidavit within 1 week, but I have also received the letter of the complaint whereby not only the petitioner, around 4 other transporters, their trucks have been tampered with. Yes.
Bring it on
I'll
record.
bring it on record. I'll bring it.
What I propose, Mr. Pathak, and I've been doing it. Let them file a reply.
My lord. My lord.
Then if you then on the basis of Gorkha, Kulja and non-furnishing of report, non-hearing, then we might allow on the returnable date. We are making it very short nowadays. So far blacklisting is concerned.
Yes, your lordship. Because though only 2 vehicles are in dispute, the rest 5 vehicles also they have blacklisted me.
So you'll be in position to file.
I'll be in position to file.
Good. We'll put it in the next week.
Very well.
Right. Then after filing of reply, if you need any time, okay, otherwise you'll decide.
Very well.
Third, Mr. K.P. Pathak, learned counsel for the petitioner. And Mr. N. Borua, learned counsel for the respondent. 1, 2, and 3. Mr. R.B. Goswami, learned counsel on behalf of Ms. M.D. Bora, learned standing counsel. Transport Department. Okay, you also get yourself apprised. Okay, Ms. M.D. Bora. You also get yourself apprised about the procedural formalities required for a prospective buyer.
Then may I make one prayer, your lordship? As per Rule 49 of the Central Motor Vehicles Rules, they are supposed to maintain the records of every vehicle that they have registered. And during initial registration, a letter under Form 22 of the manufacturer is also necessary where the chassis number is certified. If that chassis number, the letter is there when it was originally registered, then no fault can be attributed to me.
Right. The petitioner was awarded
The letter of
where is that letter?
it is at page number 208, your lordship.
200. Petitioner was issued a letter of acceptance, LOA, on 6/4/2024 for a contract work. Transportation of non-LPG cylinders in vertical position on unit rate basis X Sorpara LPG bottling plant under plant, page 1208. As per the terms and conditions incorporated therein. Full stop. The petitioner was allowed to operate 7 number of tank trucks as per the details enclosed with the LOA. Full stop.
Lordship, just trucks, not tank trucks.
Okay, trucks. Full stop. Among the 7 trucks, 2 trucks bearing
Show cause notice, your lordship will find
uh,
at page number 214.
where is the truck
Truck
number?
numbers are at paragraph number 4. AS
Truck
0,
number
paragraph number 4.
200
200 and
bearing registration number AS-09/AC-7149 and AS-09/AC-4205 were included. Full stop. On receipt of the LOA, the petitioner started operating the trucks, all the 7 trucks for the contract work of transportation. Full stop. However, on 11/11/2025, a show cause notice was issued to the petitioner alleging gross irregularities and fraudulent practices on the allegation that the chassis numbers in 212, which one? 212 serial number?
yes,
212, which one?
in it is item number 3 and 4. Serial number 3 and 4. Your
3
lordship.
and 4. Okay. The 2 trucks while providing the details of the 2 trucks, when according to the petitioner, the 2 trucks, that is AS-0109 AC-7149, had engine number and chassis number, and the other truck AS-09 AC-4205 had engine number and chassis number. Page 212 does it. Tier 4 serial number. In the show cause notice, it was alleged that original equipment manufacturer OEM
My lord.
had confirmed that the chassis numbers of the 2 trucks do not relate to the registration numbers. Right?
My lord. And they do not have such chassis numbers in their records.
I have just mentioned.
My
so
lord.
that- In response to the show cause notice, the petitioner submitted his reply on 12/12/2025.
Prior to that, one on 15/11/2025 as well.
Okay.
Page number
15
207.
Page
270.
15/11/2025. Denying the allegations Full stop. It was canvassed. That the allegations were not true as reflected from the registration certificates. Full stop. The petitioner had submitted an additional reply on 12/12/2025, stating in detail that the case of the petition is supported by the provisions of
The Evidence Act and the Motor Vehicles Act and the
Motor Vehicle Act,
Motor Vehicles Act and the Central Motor Vehicles Rules 1989.
which section?
Section 41, read
Section
with
41 of the Motor Vehicles Act 1988 as amended, read with rule
Rule 47, 48 and 49.
rules 47, 48 and 49 of the Central Motor Vehicle Rules 1989.
1980.
Full stop. However, the respondent IOC authorities did not consider the additional reply and based full stop and influenced by the report received from the OEM and without verifying the details, without verifying the records of the Transport Department, the respondent IOC authorities have proceeded to pass an order of holiday listing, page
It starts at page number 228, Your Lordship.
228. Holiday listing on 2/3/2026, whereby the petitioner has been put in the holiday listing for a period of 2 years from 2/3/2026. First of para, Mr. Pathak, learned counsel for the petitioner, has contended that apart from non-consideration of the additional reply dated 12/12/2025, the respondent IOC authorities did not furnish a copy of the report received from the OEM to the petitioner. First of, it is the report of the OEM which had influenced the decision of the respondent IOC authorities. Full stop. He has further contended that no hearing was afforded to the petitioner prior to the order of holiday listing. Full stop. Thus, there is clear violation of the principles of natural justice, as the order of holiday listing is a drastic measure amounting to civil debt of the petitioner. Full stop. Mr. Borua, learned counsel appearing for the respondent IOC authorities. Respondent number 123 has submitted that given a week's time, the counter affidavit on behalf of the said respondents can be filed, responding to the allegations made on behalf of the petitioner. First of, Ms. Bora, standing counsel, Transport Department, appearing for the respondent number 4, has submitted that she would obtain instruction as regards the 2 vehicles bearing registration number so and so, and a manner in which the ownership of the said 2 trucks were transferred to the petitioner. Full stop. Anything else from Ms. Bora?
No.
That will do? Okay.
But may I make a submission? In case the pro forma respondent is also put to notice, the issue will be clarified from them to Tata Motors.
No, otherwise their report is already there with the IOCL.
If that is an admitted question that these are not manufactured by Tata Motors, then save a lot of time.
No, that will delay the order. We are putting it, but you file your response.
I will find it.
Where is that order? Sorry, the notice? Show cause?
It's pro forma.
No, show cause. Your show cause.
The show cause notice, your lordship will find at page number 214.
Para 4, you give the, enclose the reply.
No, that will be subject.
Para 4.
Correct.
How your decision has, right? Borwata likho. He has first submitted that the reply received from the OEM as regards the 2 trucks under reference would be part of the counter affidavit.
My lord.
Right? That
My
will
lord.
do
My lord.
for the time being. If we see that some criticality, then we'll proceed further. The issue notice, no, not notice, motion only.
My lord.
Leaves the case on after 1 review.
My lord, I had only one apprehension. My clients had informed me that IOCL are on a war footing to issue a fresh tender for these vehicles. At least for 1 week, if my learned friend advises his clients to
I will
hold.
advise them, but because in the prevailing situation.
They already have vehicles, your lordship. I have instructions that they have sufficient number of vehicles. So if for 1 week.
1 week, 1 week.
One-
No. Let it be. Yeah.
I'll advise them.
Very-
Let's see.
Prima facie, it appears to be vulnerable.
2303.
Deep level.
Therefore, interim relief is kept open for consideration on the returnable date,
Deep level.
on the next date of listing.
Deep level.
Item 14. 23. 2303.
Yes,
My lord, I'm challenging the cancellation, tender cancellation order. That is at page 30. And also the subsequent, immediately thereafter, retender was issued. That is at page 31.
stands cancelled in accordance with the decision of the tender evaluation committee. What is the tender?
Tender was about construction of some block road and drainage.
Page 18.
They earlier tender.
Page
was-
18. Page
Yes,
18.
Yes. It is at page 18, madam.
Page 18.
Yes, madam.
There were how many works? 31 number of
31
works.
I was for only for 5.
5. The whole tender
Whole
process cancelled
cancelled. Because in the
and retendered.
retender, in the meantime, I was asked for price evaluation. That is by notice annexure 3, 23, page 23. Whereas in the
Yes.
subsequently, I
What right you have?
because subsequently,
No right has been crystallized.
subsequently, I represented before the respondent.
Maybe,
But my representative is still
maybe
pending. madam.
entire 31 number of works have been cancelled.
Yes, madam.
You were part of only 5,
Yes, okay.
right? They may have a justification for not below 10%, maybe. What is the new clause?
The new clause, entire thing is same, but now they have come with 10%.
So maybe that is the reason, policy decision.
But in the order that is at page 30, it has not reflected anything. madam.
Not required. That is not the law.
It should be revision by law.
Huh?
Reason order.
Reason can be given in the form of affidavit. Shall I close this?
At least my representation is there before the.
No, even no issue notice. Let them come with affidavit. Heard, Mr. S.K. Singh. You have not reached the position of the successful tenderer.
No, I am
So-
L1 in that.
No,
No, actually, that
your
was,
bid is to be accepted, sir.
the bid, the earlier tender bid was open on 29. I was present in the bid on 29/1. Thereafter, for 27 days, they did nothing on,
It is there, right, sir? Heard, Mr. S.K. Singh, learned counsel for the petitioner. And who is for the other?
I am for response number 1 and 5.
Okay, you are only 1 and 5.
5.
Mr. S.R. Burwal and Junior Government Advocate for the response number 1 and 5. Full stop. Para. The respondent Hojai Municipal Board published a notice inviting tender NIT on 7/1/2026 inviting bids for award of 39 one number of works. Full stop. The petitioner, finding himself eligible, submitted his bids for 5 number of contract works. Full stop. On 25/2/2026, the respondent number 7 issued a notice stating that any bid offered below 10% or more would have adverse impact on quality of the works, and therefore the contractor's bidders who had quoted bid value beyond 10% below of the tendered value in the NIT, in the tender values in the NIT, were requested to submit their item-wise justification with proper price analysis against their quoted bid value within a period of 48 hours. Full stop. The petitioner submitted a reply or submitted a representation in response to the notice dated 25/2026 on 27/2026. Full stop. A number of the petition and a number of other bidders had also submitted a representation before the respondent number 5 on 27/2026. Full stop. It is a further case of the petitioner that after opening of the price of the bids, price bids, the petitioner who quoted 10% below 10% of the tender value, emerged as L1 on 30/01/2026, but on 6/3/2026, the entire tender process initiated by the NIT dated 7/1/2026 was cancelled, and thereafter, immediately thereafter on 7/3/2026, a fresh NIT was published for the same 31 number of contract works, which were advertised, which were in NIT dated 7/1/2026. Full stop. Mr. Singh, learned counsel for the petitioner, has submitted that as the petitioner had emerged as L1, the cancellation of the tender process in all 5 works. in all the 5 works wherein he had submitted his bids, comma, the cancellation of the tender process is illegal and arbitrary. Full stop. Issue notice, Mr. Borua, junior government advocate has pointed out that earlier in the NIT, in the earlier NIT, there was no limit. But in the NIT dated 17/2026, comma, a new clause has been incorporated to the effect that which one, 10%?
That is clause 4, page 33.
Any offered bid value beyond 10% below to the tender value would be rejected. Full stop. Issue notice returnable on sales. As Mr. Borua, 1 and 5. Petitioner shall take steps for service of notice upon 2, 3, 4, 6, 7 by speed post reading to opening response today.
My lord, my lord, the tender is going to be open on 16, next Monday. So if it is deferred a little bit, so in the meantime, it will, the tender is going to open on
Let
16.
them open. You are pressing for interim order.
Yes, ma'am.
Further learned counsel for the parties on the interim prayer. First stop. On comparison of the NIT dated 7/1/2026 and NIT dated 17/2026, it is noticed that both the NITs were stroke are for same 31 number of contract works. Is noticed prima facie. Full stop. From the notice dated 25/2/2026. Hey, Ma window to go.
This one.
The authorities, respondent authorities in the Ujjain Municipal Board appear to have taken a decision to call for justification from the bidders who had quoted below 10% of the tender value in respect of the contract works. First one. Subsequent on 60/2023. The entire tender process initiated by the NIT dated 7/1/2026 had been cancelled. First one. From the tender cancellation notice dated 60/2026, comma, it is noticed that the tender process had been cancelled pursuant to a decision taken by the tender evaluation committee. Full stop. It was further decided that retender would be issued in due course of time. Full stop. Though some financial relaxation was given to the participant bidders, they were given liberty to participate in the same group in the re-tendering process. Post of it was there. It is there. It was thereafter the NIT dated 17/2026 has been published with a fresh with a new clause to the effect that any bid value beyond 10% below to the tender value would be rejected. No bid would be entertained beyond 10.00% below the tender value in any circumstances. Full stop. Para. The law is settled that submission of a tender in response to an NIT, in response to a notice, inviting such tenders is no more than making an offer which the state or its agencies are under no obligation to accept. The bidders participating in the tender process cannot, therefore, insist that their tenders should be accepted simply because a given tender is the highest or lowest, depending upon whether the contract is for sale of public property or for execution of works on behalf of the government or an agency or instrumentality of the state or any public authority coming within the ambit of Article 12 of the Constitution of India. All that participating bidders are entitled to is a fair, equal and non-discriminatory treatment in the matter of evaluation of their tenders. Full stop. Award of a contract is essentially a commercial transaction which must be determined on the basis of consideration that are relevant to such commercial decision. Full stop. The authority. Full stop. The matter of award of contract, the government and its agencies stroke instrumentalities have to act reasonably and fairly at all points of time. Full stop. It is only to that extent, a bidder has an enforceable right in the court, which is competent to examine whether the aggrieved party has been treated unfairly or discriminated against to the detriment of public interest. Full stop. Para. It is also settled that it is within the discretion of the tendering authority or employer to cancel a tender process. So as it is an administrative decision, no reason is required to be assigned for cancellation of the tender process at first. So if question, such reasons can be assigned in the response filed on behalf of the tendering authority stroke employer. Full stop. In such view, in the above view of the matter, this court is not inclined to pass any interim order stalling the tender process initiated by the NIT dated CC 2026 at the instance of the petitioner. Full stop. The petitioner, even if he had emerged as L1 bidder in respect of the contract was he had submitted his bids in the earlier tender process, neither any letter of acceptance stroke work order was issued to the petitioner, and as such, no right seems to have been crystallized in favor of the petitioner.
April 2204.
Therefore, only the prayer for interim relief is declined.
Supplementary list, item number 50.
Implement. Done.
Lordship, implement that has been
Huh.
disposed of by the
Who are the-
Honorable Court. And
Who are the newly implemented
Forest and
party?
Lordship, Deputy Commissioner Kamrup.
From, response number
Respondent number 4 to 7, Lordship.
4 to 7. Earlier, so and so. Forest has come in. And DC has come in.
Yes, Your Lordship.
And what is your issue?
Lordship, I have applied for electricity connection on Lordship 16/7/2025.
Government land.
It's a government land, Lordship.
And your neighbors are having electricity connection.
All are having electricity connection, Lordship. And
Instruction has come.
Lordship, in the one of the person, Lordship, with this
It will be negative equality. Don't press for much on negative equality. Let us see.
Yes, sir.
Now, one more thing has come. As per GPS coordinate, your Hoyto Hunual
Yes, sir, Lordship.
inside Hangrabari Reserve Forest.
Lordship,
One more stumbling block has come.
Lordship, in fact, today government has called the committee members for allotment of Miyadi Patta to the
Good enough.
residents. Lordship, in
Let
that
us, since all our official response is,
area is covered under the dark number.
if you get the patta, very good.
764 is
You
the revenue.
most
land.
welcome.
Yes, sir, Lordship.
Right. We'll issue notice at this stage. Right.
Lordship,
Making it short. In the meantime, if you get patta, you will get
Lordship, in
everything.
the meantime, only my humble.
Now it is reserve
Lordship,
forest.
Lordship, the similar situated candidate person, he approached before this honorable court, and this honorable court has granted the temporary connection. So there,
That fact has come that you are inside reserve forest.
Lordship, he is also in the same place, Lordship.
Government Dag is another thing.
And Lordship,
The Assam forest, Mr. Like the other one, if you invite something when the court is not inclined, like the previous one,
Lordship,
if you want to invite something from the court, you'll get it.
Lordship, only my humble submission is that there cannot be
Tell me on the Assam forest regulation then. If you want similar order, but if you are not similarly circumstanced,
Yes, that is Lordship, true, but only
reserve forest,
Yes.
you have lived since how many years there?
Lordship, I have been living there, Lordship, not, though I have purchased the land, Lordship, in the year,
Yes.
Lordship.
You are without electricity connection for how many years?
Lordship, I have been connected by Lordship neighbors.
That is a different thing.
Earlier.
Without electricity connection, without legitimate electricity connection. For how many years?
Lordship,
For how many years?
Lordship, last 1 year, Lordship.
Last 1 year.
Yes, Lordship.
Why don't you wait for 2-3 weeks more?
Now the situation is, Lordship, that the electricity connection from whom we have been availed, Lordship.
Shall I distinguish, give the, if you want immediate connection on the basis of fundamental right, give the, I'll distinguish that order. Because this has come. In the meantime, patta is issued well and good. But court cannot ignore this part under Assam forest regulation for the timing.
That is true, but Lordship, in the
That is true means true.
there is a judgment of this honorable court is that, Lordship, that when the Amsing Reserve Forest, all the electricity connection.
Sir, I am not, Mr. Sharma, I am not talking about final order.
Yes.
I am speaking
Only
about
my humble
interim relief, Mr.
There is 2 students,
Okay, then give it,
Lordship,
whatever.
for them, Lordship,
This-
at least.
I'll do it.
Only
your
temporary
risk and
connection,
cost.
Lordship. Only
At
for
your risk and cost.
temporary connection.
Assam forest regulation. Declared forest, reserve forest. No region. May apply for temporary connection.
Yes, sir. So only that much is.
That
sufficient,
is.
Lordship.
Had you applied? Did you apply?
Lordship, because Lordship, in the first occasion, Lordship.
Did you apply or not?
Not applied, Lordship.
Did you not apply?
Only that liberty may be granted, Lordship, to apply.
You apply then. That is what you want.
Yes, your Lordship.
Only for temporary connection, Lordship.
Application will come. Don't ask for a direction to install a temporary connection.
Yes, that.
I thought that you are asking for temporary connection right now. Not.
Tendency of the petition shall not be barred for
But that
application of
is,
the.
that is a right available to you all the time.
Lordship, now the situation is that, Lordship, in that area, Lordship, in fact, APDCL has not accepting any Lordship applications. That is why, Lordship. That observation is required.
Mister, it is a reserve area.
Yes.
Okay, I'll put you in the position of sub-divisional officer APDCL. An application comes. It is clear that it is for reserve forest area under Assam Forest Regulation.
Yes.
Would you proceed? You are in the process of receiving patta, right? Right?
Yes, Lord, not only me, Lordship, the other residents,
No, you are not.
that area. I am not, Lordship, but other residents, because those who are
Oh,
staying,
you are not.
those who are staying for long
Right,
periods,
Mr.
Lordship.
D. Sharma, learned counsel for the petitioner.
Only pendency of the petition shall not be barred for temporary connection, Lordship.
No, I'll not give. Where you are,
Lordship,
at least
in fact,
no understanding.
I have also applied for
Mr. S.R. Borua, 1. Mr. Aibor Thakur, planning
Lordship,
counsel.
I have also
APDCL.
applied for Miadi Patta, Lordship, that is there, page number 23, Lordship.
2 and 3. Miss Kolita, R. Kolita, M. Kolita, learned counsel, standing counsel, Environment Forest Department for the respondent number 4, 5, 6. S.R. Borua is also 7. So stop. Seeking an electric connection to a plot of land measuring 1 kata 5 lesa, covered by. Your synopsis appears to be wrong.
Covered by Dark number 7.
Cover patta number in government case, government land.
Dark number, Lordship, there is a typical mistake. And old dark number is.
Patta means a complete different thing.
Yes, yes, Lordship, that is a dark number, Lordship.
I don't know whether it is deliberate or dark number.
Dark number, Lordship.
192O stroke 764 and situated at Kanchannagar under number 1 Hengrabari Revenue Village,
Yes, Lordship.
Mauja Beltola, Dispur Revenue Circle. The petitioner has approached this court.
Only one small submission, Lordship, that a person can apply for Miadi Patta, Lordship, under the Vasundhara Act. Those persons' names are inserted in the revenue land, Lordship. As per that.
Mr. There are contrary findings.
Yes, sir.
You said revenue village.
Yes, Lordship.
They said forest reserve.
Yes, sir.
Right. That has to be first dealt with.
Determined, Lordship.
Thereafter, we can proceed further.
Lordship. And therefore, Lordship, till that, Lordship, since the 2 students are there, Lordship, they are suffering, Lordship.
You said you are having an electricity connection from your neighbor.
Lordship, now they have disconnected, therefore I have approached, Lordship. Only the situation is that is the situation, Lordship. All neighbors now.
Mister, how can we ignore this? You are having residence inside a forest.
On that, Lordship, your Lordship may kindly fix this
So,
matter tomorrow, Lordship. I will satisfy your Lordship.
Tomorrow I will not come.
On Monday, Lordship.
I will not sit.
I will satisfy your Lordship on Monday, Lordship.
On the request of Mr. D. Sharma, Land Council Petitioner, raised a case on Wednesday.
Yes, sir.
The instruction placed by Miss Kolita, Land Standing Council. Oh, sorry, you, Please. Oh, you have placed. The Standing Counsel Forest Department. Is kept with the case record. You can examine.
Yes, Your Lordship, I will explain.
18-3.
The aforesaid in
Supplementary list, item 51.
May I please, Your Lordship?
Who was for the IOC?
He is here, Your Lordship. He isn't on. He will be called, Your Lordship. Oh, he's come.
Yes.
Lordship, this is Your Lordship, is a tender, Your Lordship.
Who is the tender?
Page 28 is the tender notice, Your Lordship.
Just a minute.
Lordship.
Transportation contract.
Contract, Your Lordship. Trunks, Your Lordship. TTs.
Huh.
Now, so far as the main tender is concerned, Your Lordship, we have not, it is, we are more concerned with, Your Lordship, the corrigendum issued at page 135, Your Lordship.
Where is the original clause,
Lordship,
which has been subsequently
Your
modified?
Lordship will get it in the column number 3. As mentioned in the corrigendum dated
130,
Lordship. 5.
135.
Lordship.
Yes.
Now 136, Your Lordship may kindly come. Serial number 5.
Serial number 5.
5. Your Lordship will find the bidder should upload the self-attested copies of RC books of all offered trucks owned or attached of capacity as defined in the scope of work above, out of which the bidder must own at least one truck in their name. If the bidder does not have minimum one owned truck, then the bid of such bidder will not be considered. Then, Your Lordship, this is added. This portion was added. In case of TTs operating in the existing contract, Your Lordship will kindly note that, Your Lordship, whose ownership cannot be transferred during the pendency of the running contract, and hence the formalities for transfer or ownership could not be completed as on due date of the new tender. Such vehicle can be sold through agreement to sell. And both the seller and the purchaser bidder shall have to submit an affidavit as per the attached annexure 4041, along with the valid registration document and PESO license in the name of the seller. Now, such trucks shall be considered as own trucks of the bidder for bid qualification allocation purpose. Your Lordship, we did it, Your Lordship.
What is Annexure 14? Is it part anyway? Just
Annexure 40 is there, Your Lordship.
Is it
It's an agreement for sale, Your Lordship.
okay.
Lordship. Now, Your Lordship will kindly come
Just
to
read the entire one.
Lordship. In case of TTs operating, Your Lordship, from
Lordship, 137. Let us read the entire one.
Lordship, such trucks shall be considered as own truck of the bidder for bid qualification and allocation purpose. For such cases, bidders have to submit a caution money of rupees 1 lakh per truck up to maximum of rupees 10 lakh per tender along with the bid. Bidders shall submit caution money separately and should not combine the amount with EMD value. The details of caution money like UTR number, etc. shall be mentioned in the annexure number 42 enclosed. Wherever caution money is not submitted before the due date of the tender, then such TTs shall not be considered. Caution money shall be refunded after submission of the requisite documents in the name of the successful bidder and induction of trucks. In case of unsuccessful bidder, caution money will be refunded after the finalization of tender. In case the bidder fails to submit the required document with change of name, etc., within 4 months of issue of LOI. This is how we are concerned with this, Your Lordship. Suitable penal action shall be taken, which may include EMD, forfeiture, caution money, forfeiture, termination of order of such TTs, and blacklisting of such TTs. Under no circumstances will the above mentioned timeline be extended In such cases, the contracting corporation reserve the right and shall be liberty to induct treaties as per the methodology mentioned in a tender to fulfill the shortfall arising thereof. Such bidder shall submit documentary proof of invoice between 1/1/2025 to 15/4/2025 of such treaties to confirm that they have operated, are currently operating under the existing contract with any one of the OMCs. This is, Your Lordship, we are concerned with. Now, what has happened here, Your Lordship? If Your Lordship wants.
This corrigendum was prior to bid closing date.
Lordship, now Your Lordship will kindly see that they have given this 120 days of Your Lordship extra time so that Your Lordship, in view of the fact that Your Lordship, it is an admission on their part that when they are under the regular contract, it will not be possible to transfer the ownership, Your Lordship, as well as to obtain the PESO license, etc. Your Lordship. Therefore, this window period of 120 days is given in this particular corrigendum. Your
4
Lordship.
months, 4 months.
4 months, Your Lordship. Now, Your Lordship will kindly find that, Your Lordship, 16/9/2025 letter of acceptance were issued, Your Lordship, in our favor. And all these petitioners, Your Lordship, has got a letter of intent. That is, Your Lordship will get it at page.
It says about LOI.
LOI, letter of
And
intent.
whether there is distinction between LOI and LOA.
Lordship, I will.
Conceptually.
LOA, Your Lordship.
LOI.
Lordship. I will.
That corrigendum is with regard to LOI.
Your Lordship. Now, Your Lordship will kindly come.
Is there any LOI?
Lordship will LOA, Your Lordship.
That is why because conceptually letter of
Lordship.
intent and letter of acceptance is different.
Lordship. Then, Your Lordship, work order has also been issued subsequently, Your Lordship.
No, is there any LOI?
No, Your Lordship. LOA has been issued. That is, Your Lordship will get it at page 141, Your Lordship. These are the letter of acceptance. Your Lordship will kindly come to page 145. Physically, clause number 2, physically place all the ready-built TTs at the location for physical inspection with all licenses, documents for original verification within 30 days from letter of acceptance. Then execute the standard agreement for so and so, the submit documents, declaration, so and so. Now, Your Lordship, agreement has also been executed between us. Now, before that, Your Lordship, what has happened, Your Lordship? So far as the
Page 145, you have offered 12.
12, Your Lordship, and out of 12, we are now concerned with 2. 10 has no issue.
Which one? Which one? 145.
Lordship. 145, Your Lordship will find. 141, Your Lordship, and 145, Your Lordship. These are the vehicles, Your Lordship.
Out of 12, which one?
Your Lordship, last two. Registration number 95 and 96, Your Lordship.
Okay.
These are the 2, Your Lordship, which were
where you letter of sale or agreement for sale.
Agreement
you
for sale.
submitted.
Lordship. These 2.
Okay.
Now, Your Lordship, these 2. Now, Your Lordship, in the meanwhile, Your Lordship, before that, Your Lordship will find that page 148, Your Lordship, may kindly come. $149, 149, Your Lordship. Annex 5, Your Lordship. Existing contracts, Your Lordship, of the vehicles, Your Lordship. This is Manish Kumar Jain, Your Lordship. From him, we have purchased. Agreement for sale is there. Agreement to sale is there. Now, these contracts were, Your Lordship, extended by 2 months, Your Lordship. on 16/8/2025, Your Lordship. Your Lordship will find, we refer to the existing bulk LPG transportation contract agreement with respect to tender number so and so executed between yourself and our corporation for providing tank trucks for transportation of bulk LPG on the terms and condition of the contained in the said transport agreement. The said agreement was valid till 31/8/2023. We intend to extend the existing bulk LPG transportation contract for a further period of 2 more months up to 30/10/2025. Extension shall be on the following terms. E, Your Lordship, clause number E, that proposed extension shall be valid for a period of 2 months with effect from 1/9/2025. That is up to, Your Lordship, 30/10/2025. And our LOAs were issued, Your Lordship, on 16/9/2025. Now, Your Lordship, the 4 months period, window period was given, Your Lordship, on since these trucks were under agreement with the IOCL and it is running till it contract subsists, it will not be possible for the agreement to sell the tenderers to, Your Lordship, get the requisite documents, Your Lordship. That is why this window period is given. Now, because of this extension period, Your Lordship, now we have got only 2 months, Your Lordship, to get the vehicle registered in my name, and then, Your Lordship, to obtain PESO license and other relevant, more particularly PESO license, Your Lordship. 2 months in between, Your Lordship, has these vehicles remained with the IOCL, Your Lordship, under the existing contract, Your Lordship. Now, Your Lordship, in the meanwhile, Your Lordship.
Mandatory.
No, it's a mandatory.
Come to page 150.
Lordship. Yes, Your
Clause
Lordship.
5.
Clause 5. But, Your Lordship, it is in
It
not.
is if that seller and purchaser agrees. If he say that
That is fair, Your Lordship.
seller
Yes, Your
seller can opt out.
Seller could have, Your Lordship.
Could have.
Could have.
But which is not in your hand.
Lordship, not in my hand.
Definitely not in your hand.
Not my hand.
Right.
Lordship.
But all
It
these
is
have to be
between
read
seller.
together.
Lordship. But the point is,
It is
Your
clear
Lordship.
for that
Yes, Your Lordship.
this it shall be considered you are not willing to for extension.
That is there, Your Lordship.
Inviting no penalty.
No penalty. Your Lord, now, Your Lordship, the point is, Your Lordship, that ultimately, Your Lordship, the vehicles remain with them, Your Lordship. So ultimately, Your Lordship, although 4 months time has been given, and it was known to the IOCL, Your Lordship, authorities, that these vehicles has already been offered to them under agreement to sell as per the corrigendum, Your Lordship. And then, Your Lordship, they have issued work order also, Your Lordship, to us. Yes, not to good. Work order to yes. One.
So if we go by extension of 4 months, it is 16 January
Lordship.
2026.
26. Now, Your Lordship will kindly see, in the meanwhile, we obtain registration ownership has been changed in respect of all the tenderers, Your Lordship, all the petitioners, Your Lordship, within that period of 4 months, if we take it from LOA, date of LOA, Your Lordship, all of them has registration has been changed.
Within 4 months.
Within 4 months. But the point is, Your Lordship, the PESO license, some people, Your Lordship, obtained after 4 days, Your Lordship, some 15 days, some 20 days, Your Lordship. Now, Your Lordship, what they did, therefore, Your Lordship, they issued a show cause notice, Your Lordship, to us. And that show cause notice, Your Lordship, will get it at page 152. These are all same dated, Your Lordship. All are dated the page 152, Your Lordship. May I read that show cause notice, Your Lordship? Kindly note that the above mentioned TTs were considered as own TTs during evaluation of tender, which was in line with the provision of the tender publication point number 5 of the corrigendum dated 6/4/2025. As per the conditions, the transfer of the truck documents, registration certificate, and PESO license in the name of the purchaser are supposed to be completed within 4 months for issuance of LOA, please refer to the following clause mentioned in the corrigendum. Then the quotation of the clause, your lordship has already read it. Since you have failed to submit the required documents, RC, PESO license in the name of the purchaser of the TTs within the stipulated time of 4 months from the date of LOA, it calls for action as stipulated under the above mentioned clause. Hence, your above mentioned TTs has been placed under suspension, your lordship. Now, there are two parts, your lordship, in this so clause. One is, your lordship, they have already suspended, your lordship, and second part, your lordship, is the so cause, your lordship, regarding the consequential, your lordship, the actions that they wish to take against us, your lordship. Then, your lordship, punitive action like forfeiture of EMD, caution money, including for termination of the contract for these TTs should not be initiated against you. Now,
So this is confined to those trucks.
those tracks.
Not the entire.
Not the entire track.
Right.
Now, your lordship, we have replied to the so cause notice, your lordship, but your lordship, they have not passed any order on that, your lordship, but suspension still remains, your lordship.
It is against suspension.
That is, your lordship. Essentially, it is against suspension. The other part, your lordship, since so cause we have already replied, your lordship, and
Yes.
I know that firstly, there is the query, that difference between an LOI and an LOA. I understand, LOI is non-binding.
LOA is not binding.
LOA is binding. Here, my lord, in this case, my lord may kindly come to page 141 for a moment, for the LOA which has been referred to by my senior friend, number 141. 141, lordship, yes. Now, my lord, might kindly come to page 146. Following to be noted, the contract will be guided by all terms and conditions of the tender and other documents furnished and related correspondence during tendering process / period. Formal work order shall be issued for the above office after physical verification of TTs at the location and on submission of the required documents. D. All terms and conditions stipulated in the tender notice, special terms and conditions, additional instructions, special tender conditions, declaration, agreement, and other documents furnished to the tender and field correspondence shall form a part of the contract. In case trucks are offered under agreement to sell, the transporter shall conclude the sale of the truck mentioned, the above mentioned trucks, including registration, statutory license, and other approvals necessary and applicable as per tender, and submit the same within 4 months from the issuance of an LOA. Now, my lord, by furnishing of the LOA, it is, in my humble submission, my lord, this document is contingent on fulfillment of the terms and conditions which have been laid down in the tender. The IOCL, the corporation, has not committed to going forward with the work orders and not going and not fulfilling the terms of the condition of the tender, my lord. And by the corrigendum which my learned friend has relied on, 4/4/2025, that corrigendum was provided to enable as a privilege, my lord, to the tenderers to submit trucks if provided they do not have trucks, submit trucks of existing contracts as their own contract, subject to the fulfillment of the requirement. Since that was not done, and since both the two tenders are separate tenders in their own right, in my humble submission, my lord, the corporation's actions cannot be, my lord, at this point, my lord, be disputed. That is my limited ground.
and
This is a conditional document, the LOA. The LOA does not commit to anything, my lord. It says that fulfillment of these terms and conditions and the work orders were issued immediately thereafter within a period of 1 week, 27. But the 4-month period still remains.
No, at this stage, suspension is on.
suspension is on.
Nothing, no
No, so far as
consequential action has been
consequences,
taken.
but your lordship, suspension means, your lordship, we are not be allowed to operate, your lordship. That's
Right, privacy, it is there.
No, no, your-
That things beyond your control had created this situation.
lordship, that is
Right,
what,
but
lordship.
otherwise, everything is in conformity with the
yes.
terms and conditions of the tender.
Tender, we have, no, your lordship, we have also, your lordship, followed it, and now, your lordship, principle for which, your lordship, they have brought in this corrigendum with a window period of 4 months, your lordship. If your lordship sees again read this particular.
I have read and
yes,
calculated it is
in
16/1/2026.
spirit, your lordship, of this, your lordship,
So
is
in tender, where is all this stays at a distance?
No, your lordship will kindly see.
We are trying to find out, yes, situation has.
Beyond my control.
Yes, beyond your
Control,
control.
your lordship.
But it is not that they have not acted. What are terms and conditions? They have also acted.
No, they have acted.
Yes.
But the spirit of this corrigendum, your lordship,
discretion is also there.
had it been a case, your lordship, that we have.
Corrigendum, whether they do not have any power. It is a privilege extended.
Lordship, privilege.
That's just because a person is not owning, okay,
Lordship.
he must own one, right? But if his thirst is more, then okay, we will satiate the thirst. Let us have agreement to sell. We'll extend the benefit to them, provided within 4 months.
Lordship. Now,
Right.
your lordship will kindly see, your lordship, that these 4 months, your lordship, the logic behind these 4 months, your lordship, there could not have been any 4 months, your lordship. The logic is that since it.
Terms and conditions, Mr. Bhattakur.
No, I am not on
It is
terms
that
and
they are the best person.
No, no,
they,
that is
they
their
know what to do, how to operate.
No, your lordship.
Right.
had
Question
it-
is whether any leeway can be extended
Lordship,
to
that is-
you. That is the
that
only
is
thing.
only you. Okay.
If you go by the strict terms and
Lordship.
conditions, you are otherwise out.
That
Right.
is-
If
Since-
if we tender jurisprudence is quite clear.
Absolutely, lordship,
Right.
what has fallen from your
But
lordship.
question is, as an employer, whether they can
Give a
extend
leeway
the
or-
benefit to leeway within their jurisdiction,
Lordship,
which they can extend.
Lordship.
Right.
Lordship.
That they can examine and consider,
Lordship.
because otherwise, in the meantime, you have fulfilled.
Fulfilled your lordship.
Right.
That's
That is a matter to be examined by them.
lordship.
Right. We
Lordship.
cannot issue mandamus. Do it.
No, your lordship, that is there.
For that purpose, Mr. Sharma is the best person to.
Lordship.
Understand our requirements. In fact, the period of 4 months was granted because my senior has stressed on that.
Right. We are not tinkering with the terms and conditions. Only question is that you as an owner or employer has the discretion and you can give the leeway to them. In the meantime, since they have in the meantime complied with the conditions and situations were beyond their control,
Lordship.
because you itself extended the term of the existing contract with whom this petitioner entered into a contract as a proposed purchaser with a proposed seller.
Absolutely, ma'am.
Right.
But my lord, in this tender, in this instant tender, the corporation does not have an idea or knowledge as to which existing contract with the corporation will my senior.
Right.
So the liberty.
Now it has come to your knowledge.
Some to our knowledge, we understand that.
Take a call in the meantime on the representation.
Lordship.
On a representation, take a call.
Lordship.
Right. He has explained all the situation and the agreement was with you only, which was extended. So take a call. Right. Till then, you do not consider, first you disposed of their representation, which is pending.
Lordship.
Right. Till then, go for alternative arrangement.
Lordship.
Right. That is the best way we can conceive, otherwise not. Third, Mr. S. Bhattakur, learned counsel for the petitioner, and Mr. M. Sharma, learned counsel appearing for learned counsel for the respondent number
2, 3, 4, 5, and 6, my lord.
5. Any Mr. Roy is there? SS Roy. A.K. Dotto, learned standing central government counsel for the respondent number
Respondent number 1.
Stop. Para. You give the how many offered?
Lordship.
Each of the petitioner, how this petitioner offered 12.
12.
Out of that, 2 turned out to be under ATS, right? Please give correctly. I'll not go in.
Lordship, I will.
Pursuant to a notice inviting tender NIT for a contract work page 28, bulk LPG termination, transportation contract by road for the state of Assam and Meghalaya. The petitioner offered 12 number of tracts in his bid. Full stop. as there was provision in the bidding document to offer trucks in respect of which tank trucks, in respect of which the bidder had entered into an agreement to sell ATS with owner or within bracket as owners of tank trucks, then the bidder can also offer can also offer such TTs as own trucks. Full stop. By a corrigendum issued or published on 4/4/2025, certain modifications were carried out. Carried out in respect of the clauses earlier existing as regards PESO. What is the full form of PESO?
Petroleum and explosives.
Petroleum and explosives. Petroleum and explosive
Security.
security organization within bracket PESO licenses. And the change of name of and the transfer of ownership of the TTs which were placed under ATS. Full stop. It is a condition for such bidder to submit the required documents with change of name of ownership of the TTs within 4 months of issuance of LOI along with the PESO license in the name of the bidder as the who as a proposed purchaser had entered into ATS with a proposed seller. Full stop. A letter of acceptance was issued to the petitioner on 16/9/2025 accepting 12 number of TTs, including 2 TTs bearing registration number page 145 pencil ideas.
Page 168 I have mentioned in a tabular form.
145 pencil ideas. As within 4 months from the LOA, the petitioner could not offer the 2 TTs under ATS with requisite documents regarding transfer of ownership and PESO license, a show cause notice was issued on 5/3/2026, stating inter alia that on the putting the said 2 TTs under suspension with immediate effect. It is mentioned in the show cause notice that in the event the reply of the petitioner is not found satisfactory, then consequential punitive action like forfeiture of EMD, caution money, and termination of contract, etc., would take place, would be initiated against the petitioner. The petitioner submitted a reply on 7/3/2026, explaining the situation as to why the requisite conditions could not be complied within a period of 4 months. First off, one of the ground cited is that the proposed purchaser of the said to ATS in the said to ATS was in an existing contract with the IOCL with validity up to 31/8/2025. First off, however, the validity of the said existing contract was extended to 31/10/2025. As a result, the petitioner as the proposed purchaser could not complete the requisite formalities of transfer of ownership and of peso license in his name within such period of 4 months. First of, however, the petitioner could complete the requisite formalities of change of ownership and peso license, obtaining peso licenses in respect of two TTs in the meantime. First of, apprehending that the petitioner or action as indicated in the show cause notice would be initiated, the petitioner is before this court by the instant writ petition. First of, para. Mr. Sharma, learned counsel appearing for the respondent IOC authority has submitted that the terms and conditions of the tender process under reference is independent of any other contract the IOC had entered into. First of, the compliance of the condition of terms and conditions of the present tender process, of the tender process under reference, including the conditions of obtaining or placing the requisite documents as regards change of ownership and obtaining peso license within a period of 4 months from the LOA has been adhered to by the respondent IOCs, and as such, no fault can be attributed to the respondent IOC authorities. First of, where the matter would require examination, issue notice returnable on so and so, as so and so has appeared accepted. Para. Extra copies 2 working days. It is the contention of the petitioner that though the requisite formalities of change of ownership and obtaining peso licenses in respect of the 2 TTs within bracket under suspension could not be completed within a period of 4 months from the LOA, despite regions beyond the control of the petitioner. As indicated in the reply to the show cause notice, the petitioner could, with his best efforts, complete the requisite formalities before the show cause notice, before issuance of the show cause notice. First off, the said facts have been highlighted in the reply to the show cause notice submitted on 7/3/2026. First off, the respondent or IOC authorities have not have not given consideration to the regions, to the reply to the regions,
As yet,
huh?
as yet, just been 6 days.
Regions explain in the reply to the show cause notice. First off, as the petitioner, suspension is hardly 10 days.
Lords. No, your lordship, why we apprehended, your lordship, in other parts, your lordship, suspended, so cause notice, and immediately order has been issued, your lords.
As the as a genuine apprehension has arisen for a petitioner, as a petitioner stated that a genuine apprehension has arisen that the petitioner, the punitive action, as indicated in the show cause notice, would be taken, wherein no fault can be attributed for the delay, wherein no fault can be attributed to the petitioner solely. Such drastic action, the drastic action like termination of the contract, and but here no blacklisting.
No, blacklisting is not.
They have not indicated.
Blacklisting is not.
No, it is not there.
No.
It
I
was
have
one of the actions they could take,
Lords.
right? As
That
per
has
the
not-
corrigendum.
No, that I have,
Consciously, they have not
I
done.
have not stated that also.
No.
Lords.
For me
Oh,
to
Lord.
understand
Lords.
whether the
Blacklisting is
necessity to pass any order or not,
Lords.
that is to be considered from the show cause notice.
Lords.
It is expected that the respondent IOC authorities shall give due consideration to the regions, to the explanation provided by the petitioner while taking a call, or while taking a call, pursuant to the show cause notice. Full stop. There. It is. Mr. Bottomway submitted that mere failure on the part of a contractor to comply with all the terms and conditions for bona fide region cannot be a ground for the employer to take any drastic measure like blacklisting or holiday, etc. Right. It is therefore observed that pendency of the petition shall not be a bar for the respondent IOC authorities to consider the reply to the show cause notice submitted by the petition and the regions mentioned therein, and to pass a final order on it. Full stop. Any final order passed therein is made subject to further orders of this court. Because they have indicated other actions.
Lordship,
So mere failure now is that cannot invite
Lordship,
drafting measures.
may I make a prayer, Your Lordship, that Your Lordship, till this so-called reply was disposed of, Your Lordship.
If it is further observed that till the respondent IOC authorities give final consideration to the process initiated by the show cause reply, the respondent, and there shall not be an alternative arrangement
Lordship.
as against the two TTs placed under suspension.
Lordship.
There's one more detail, Madam, that I'd like to point out, Madam, page 153. 153. One small detail. Since we have taken up, Madam, Lordship has taken up item number 51. Madam. 153. Madam. Your Lordship, LOA which has been referred is dated 29/20/25.
Okay, date beside you.
Pawan Baid is also one of the petitioners in item
Date,
number.
remove the date LOA.
Lordship.
No, that's
It will be difficult for me to pass.
I will do that, Your Lordship.
LOA, simply LOA.
22nd April.
What is Shruti Agarwal? How many? 2 TTs.
3 TTs, Your Lordship.
3 TTs. Aida. We are not indicating PSO license. I have said that before so cause
Lordship.
you have obtained
Lordship.
and transfer of ownership also before so cause.
Before so cause.
So this is generalized,
Lordship.
right? Mr. Sharma,
Yes, ma'am.
if you want to have it, this one you have.
No, that's fine.
Lordship.
Apologize.
Khali yaar, TTs kera mon rakhiyo. What is the so cause notice? Date is same.
Same date.
Okay, dates.
Dated same. Replies are also
Okay,
same.
up to 56.
Lordship. Deeply obliged, Lordship.
এখন কি? এখন সরিব। ফাইলের ভিতর।
Item 57.
Heard Mr. NNB Choudhury, learned counsel for a petitioner, Ms. Z. Bora, learned standing counsel, Agriculture Department, for the response number
1, 3 and 6.
1, 3, and 6. And any government advocate? No. The learned standing counsel, Assam Seeds Corporation, is found absent to the on call, though the name of the learned standing counsel, Assam Seeds Corporation, is reflected in the call list. The petitioner has approached this court stating earlier that the petitioner
Page 26.
the petitioner participated in a tender process initiated by the respondent Assam Seed Corporation Limited for supply of various items, including Ruby hybrid vegetable seeds. Full stop. Having emerged successful, the petitioner was issued a supply order on 39/2000
30th 2020.
2020,
Page 25.
wherein along with Annexer 1, wherein the name details of the supplies required to be made were indicated.
Annex
Along with the supply order value. So the petitioners claimed that he had duly executed the supply order and the respondent authorities had acknowledged the receipt of the delivered items. So the petition had therefore submitted a bill for a total amount of rupees 4,06,887.28. So as the said amount has not yet been released, the petitioner is before this court for appropriate direction, seeking appropriate direction for release of the same amount. Post of as Mr. Somorial and standing as Assam Seeds Corporation Limited is found absent to the on call, is the case on 23.
SC agriculture maybe sold.
The name of SC agriculture is to be reflected in the respondent side in the contest.
Order no steps. Item 15.
Yes, Mr. Khadunia.
But here, in fact, my learned friend, she appeared malad, on the date of listing motion, malad, on that day, learned counsel was not there. Subsequently, I have served a copy, my lord.
Heard Mr. N.J. Khadunia, learned counsel of the petitioner. Miss Terangpi, learned counsel, has entered appearance on behalf of both the respondents. First stop. As the respondents have entered appearance. Ms. Terangpi, yes, you need how much time?
2 weeks.
Okay, has paid for and is granted 2 weeks time to obtain necessary instructions and to file counter affidavit, traversing the contentions of the petitioner. Post up, release the case on so and so.
Obliged.
6-4. For admission, item number 16.
May I please, your lordship. Lordship, this matter otherwise infructuous, lordship, because the contract term is already expired, lordship. Only one observation may I pray, lordship. The SD money may be released, lordship. But
Where is Mr. Standing Counsel? Which department?
forest, lordship.
Forest. Where is Mr. Forest? Call somebody. Or otherwise, you will observe that if the petitioner is entitled for refund of the security amount, that same shall be. But first, let them come. Look, there are many standing counsel for forest.
Item 18.
All right, this matter may be closed by giving certain liberty to me, if necessary, to approach again, my lord. My lord, lordship may turn to paragraph, last page of my writ petition at page 68.
Last page.
There is a chart.
Last page of the writ petition. Meaning never annexer.
Page 68.
Annexer.
Annexer, my lord. So
Okay.
I have been doing, my lord, various contracts since my lord.
83 lakh.
My lord, from 2015 to 20, these security deposits were not paid to me when I came before a court, my lord.
Okay, this is one of the prayers.
Yes. Then, therefore, I came. Then, my lord, on this, FCI has made payments against most of them. I will rely on FCI's own affidavit, which your lordship will find at page 80. They have given most, I think, around 60. Page 80. As your lordship-
Yes.
Yes. They have 1, 2, 3, 4. Serial number 2, serial number 4, serial number 5, and serial number 10. There were certain litigations. For example, serial number 2, WPC 3249, where your lordship passed a judgment in my favor. FCI went on writ appeal. My lord, that is presently pending. Things like that. And then again, serial number 4, it is also pending, my lord. Then another is
So
pending.
2, 4, 5, and 10.
10. These are pending. So far as, my lord, the 24, 25 were concerned, last occasion they said that no demand, we didn't produce no demand certificate. It has a requirement. We produced and, my lord, they paid it. Let me tell you.
So
my
24,
lord,
25, no dispute.
no dispute. So, my lord, I pray that, my lord, your lordship may dispose of this case, close this case.
Okay, we quote.
By giving liberty to us to claim as this in respect of the, my lord, litigation matters which are under litigation.
Okay. So we
In
put
future.
this in the order 2, 4, 5, and 10. Okay. Heard Mr. A.C. Barbara, learned senior counsel, assisted by Miss
And
they learned counsel for the petitioner, and Mr. P.K. Roy, learned standing counsel,
Not selling out.
learned senior counsel, assisted by Mr. and
SK Chakravarti.
S.K. Chakravarti. learned counsel for the all the respondents, full stop. Among in this petition, the petition has approached this court by the instant writ petition, seeking a number of reliefs, full stop. One of the reliefs sought for is for a direction to refund the security deposits
In respect of various work.
various work orders as delineated in Annexure 11 to the writ petition, wherein the petitioner had listed 30 number of contract works, wherein at the time of institution of the writ petition, the security deposit amounts were not released. Full stop. Para, Mr. Borbora, learned senior counsel, drawing attention to the stand taken by the respondent FCI authorities in the counter affidavit,
Page 80.
and more particularly, to Annexure A, supplementary affidavit.
Additional.
Okay, additional affidavit. Filed on 15/9/2023. Has submitted that out of the 30 contract works, the issues issues regarding return of security deposit amounts security deposit amounts
Serial numbers.
have been resolved in respect of 26 number of contract works.
Right.
Full stop. He has submitted that in respect of 4 contract works.
Serial number 2, 4.
I'll quote it in the row itself. Don't worry, so that there is no confusion.
This is not my submission with regard.
No.
I'm
I'm recording. I'm recording a submission.
I'm relying on their affidavit.
কি করলো? নাম রেখো। The issues regarding return of the security deposit amounts have not yet been resolved. Full stop. Para, on query, Mr. Borbora has submitted that in respect of the following contract works, the security deposit amounts are not released till date.
Serial number 2, 4, 5, 10.
Page 80, row number 2, row number 4, row number 5, and row number 10.
But my instruction is otherwise. It's not that. My instruction is only with regard to 2. I find a rate appeal is pending, my lord, the senior said. Otherwise, others are settled my instruction. But then the latest instruction I didn't get, but then first take that payments.
Writ petition is pending, and one matter is, my lord, before the redressal.
In the case, my lord, if there is any pending release, my lord,
Mr. Roy, Learned senior counsel for the appearing for the respondent FCI authorities has submitted that he does not have the latest instructions as regards release of the security deposit amounts in respect of aforesaid 4 contract works. Full stop. Para.
My lord, the affidavit clearly mentions that he's pending WPC.
Right.
No.
2 I said. So I said it is rate appeal is pending.
Now it is writ appeal is pending, I know.
It is submitted at the bar that in respect of the contract work, quote unquote, NLP to NLP, row number 2, not Lakhimpur. A litigation is pending in the form of a writ appeal as on date. And the issue regarding the return of security deposit amount
4 and 5 also, my lord, they mentioned.
can be finalized only after disposal of the writ appeal. Full stop.
And 2 items, my lord, writ petition pending. 4 and 5
4 and 5 pending.
pending.
Okay.
5, my lord, name is given by their affidavit.
Similarly, in respect of the contract work, MLC Nagaon, a writ petition is pending.
And also 4, my lord, that is I am doing that case, a writ petition is pending.
Okay, 4 and 5.
And on 10, my lord, after the writ petition, it is going to, my lord, they have a grievance redressal forum. There we have filed an appeal that is
Okay.
pending.
Okay.
All these cases, my lord, I am appearing.
He would have liberty to approach again. No issue.
I cannot oppose that prayer.
লিখো কেনেকে NLP লিখিল না NLP to NLP next to লিখিব item of in respect of the contract works Binduguri to Binduguri and MLC comma Tejpur and MLC Nagaon. 2 other litigations are pending. Full stop. In respect of the contract work Binduguri Interstate comma Tejpur, the petitioner has approached the grievance redressal forum of the FCI.
Grievance redressal committee, no?
Committee of the FCI, and the appeal
pending
is
there.
pending as on date. Full stop. In view of above obtaining fact situation, Mr. Borbora has submitted that since the other issues have been resolved and the matter of return of security deposit amounts for the aforestated 4 contract works are pending at different fora, the writ petition can be closed at this stage with liberty to the petitioner to approach
In respect of these in future.
to seek appropriate remedy in case the petitioner finds himself aggrieved in any manner after the
Conclusion of this litigation.
after conclusion of the pending litigations in the form of writ appeal,
petition.
appeal before the grievance redressal committee, etc.
And writ petitions.
Stroke writ petitions.
Good
enough.
That's it.
Mr. Roy, learned counsel, senior counsel appearing for the respondent, FCI authority has submitted that in view of the above prayer made on behalf of the petitioner, he has no objection. If the writ petition is disposed, the present writ petition is disposed of with such liberty.
Liberty.
Full stop. In view of the consensus arrived in the in view of the consensus arrived at by the learned counsel for the parties in the aforesaid manner, this writ petition.
Let the liberty come from your hospital. Because let it not, because that case, we approaches, if I take the plea of non-maintainability, who are you to say non-maintainability? The board has given him liberty. That's because
I thought that such a consensus would come from a senior counsel. Okay.
Should we wait for the outcome of the litigations? I am ready for that.
In view of taking into consideration the submissions made by the learned counsel for the parties, this writ petition is closed. Full stop. Liberty stands reserved to the petitioner to avail appropriate remedy in case in case the petitioner's request for return, or in case the petitioner is aggrieved in any manner with the outcome
With withholding of security.
If the petitioner is, if after, what is the litigation, if after, what do you, if after final outcome of the writ appeal, stroke writ petitions and appeal before the grievance redressal committee in respect of the 4 contract works,
In future,
revised stance result so to the petitioners. If after disposal of the so and so, the petitioner finds itself aggrieved. After disposal, I am not saying that, finds itself aggrieved
by
in
non-refund of
any manner with regard to his claim for refund of the security deposit amount
that's all.
in respect of the aforesaid 4 contracts.
That's all. Obliged.
Huh? E60. Item?
16.
Oh, 16, yes.
Item 16.
Yes, please repeat your submission.
Lordship, there is this petition otherwise infectious, Lordship, as the term has been expired, Lordship. But one observation, Lordship, the HD money may be released by the authority.
No, because because he is a defaulter, Lordship. He has not paid the case money, that is applied for renewal, nothing, Lordship. Rule doesn't provide for release of the security.
What is the issue?
Issue is, Lordship, his contract was terminated during the period of COVID-19, Lordship. Page 40.
So termination would entail forfeiture of security deposit.
No, Lordship, there was no pending outstanding till it was when it was suspended, Lordship. Otherwise, I am entitled for the non-issuing of work order against the earlier case.
Petition receive Khataka send money contract and as per agreement. Self-pay advance
And Lordship, kindly turn to page 37, Lordship.
Just a minute. Your earlier petition was dismissed.
Lordship, with some observation, Lordship, which was not complied by the.
Remission. File remission, representation for remission.
Yes, remission of.
Right, without taking any coercive measure on the said petitioner. Neither comply with the There is a speaking order.
Yes, Lordship.
Where is the speaking order?
Page 74.
Page 74, Lordship.
What is the consequence of termination of the contract under 38(6)? Minor mineral concession. Minor mineral.
Before the payment of installment of debt rents, contract money, royalty, contribution to environmental development restoration prevention fund, the amount will be payable along with interest at the following rate, the chart your lordship.
38,
36,
Rule 38.
38. If Rule 38 clause 7(5), your lordship, that clearly says that the company authority may terminate the marriage concession with or without forfeiture of the whole or security deposits or part thereof as deemed appropriate in such cases without any further opposition.
So it is silent. It is silent.
It is silent. That we can,
You take a call.
it says that with or without.
Without forfeiture of the whole of the security deposit or part thereof as deemed appropriate.
As deemed
So far that is concerned, that is not there.
It's not there. It's a representation was there only for.
No, the speaking order.
The speaking one doesn't say that. Speaking
It is
order-
silent.
It's silent.
So you have to take a call.
On security one, because
Part or full, whatever. Take a call
on security.
on security deposit.
And it is also mentioned in the lordship in the contract
So
agreement.
they will take a call by passing another speaking order, right? Okay, heard.
T. H. Chaudhary.
Mr.
T. H. Chaudhary.
T. H. Chaudhary, learned counsel for the petition, and Mr. R. R. Gogoi, learned standing counsel, Forest Department for
Respondent 1, 2, 3, 5, then 5.
1, 2, 3, and 5. Mr. Borua, you are there?
I am for respondent.
Mr. S. R. Borua, learned junior government advocate Assam for the respondent number 4. 6 is not a.
Yes, sir.
Okay. The learned counsel for the parties have referred to a speaking order dated 27/1/2022, passed by the respondent number
As per the
2, whereby most of the operative part of the order reads as under page 76 order likha ase, huh? Pehla. Mr. Chaudhary, learned counsel for the petitioner, has submitted that the speaking order is silent as regards the matter of refund of the security deposit. Full stop. Mr. Gogoi, learned standing counsel, First Department, has submitted that if if any consequential with regard to the matter of security deposit, the provision for its forfeiture or refund is governed by subclause 6 of subrule 7 of Rule 38 of the Assam Minor Mineral Concession Rules 2013. Full stop. Para. Sub-Rule 7 of Rules 38 of the Assam Minor Mineral Concession Rule 2013 has provided as under. Para. From Sub-Rule 6 of Rule 7 of Sub-Rule, sorry, from Sub-Clause 6 of Sub-Rule 7 of Rule 38 of the Assam Minor Mineral Concession Rules, it transpires that the competent authority, while terminating a mineral concession, has to observe whether such termination is with or without forfeiture of the whole of the security deposit or part thereof, as deemed appropriate. Right? Post stop. The speaking order dated 27/1/2025 is found silent in the matter of forfeiture or refund of the security deposit, either in whole or in part. So in such view of the matter, the respondent number 2 shall take is required to take a call as regards refund or forfeiture of the security deposit, either wholly or partially, pursuant to termination of the mineral concession. Full stop. It is full stop. In view of the above obtaining fact situation, in view of the aforesaid, view of the above facts and circumstances, this petition is disposed of with a direction to the respondent number 2 to take to take into consideration the matter of refund or forfeiture of whole of the security deposit or part thereof, as deemed appropriate, pursuant to termination of the mineral concession by the speaking order dated 27/1/2022, and thereafter to pass a region order within a period of 1 month from the date of receipt of a certified copy of this order from the petitioner at his office.
That was one thing that the petitioner submitted representation, because this speaking order was passed based on representation submitted by him on this.
Okay. Is disposed of, allowing the petitioner to submit a representation in the matter of with regard to his prayer for refund of the security deposit the petitioner had deposited at the time of for the mineral concession granted to him in respect of Katakhal Sand Mining Contract Unit number 2 within a period of 2 weeks from today. Post op. In the event the petitioner submits such representation, the respondent number 2 shall consider such representation and thereafter shall dispose of the same within a period of 1 month from the date of receipt of such representation in terms of in terms of subclause Roman 6 of Sub-Rule 7 of Rule 38 of the Assam Minor Mineral Concession Rules 2013 as amended and on its own merits and the facts and circumstances with regard to grant of mineral concession in respect of the mining contract unit named Katakhal Sand Mining Contract Unit number 2. This order disposes of the writ petition.
Item 19. May I please, Your Lordship?
What is the stand taken in the affidavit?
Lordship, may kindly come to page 36, paragraph 5, Your Lordship. 5 and 6, Your Lordship. They have admitted the liability, Your Lordship. And
Who admits the liability?
Your Lordship,
Deputy Commissioner.
Deputy Commissioner. Your Lordship.
Now, Panchayat, you file your reply within 2 weeks. But Mr. Uketeka,
Lordship.
Land Council of Petitioner, Miss Thapa, P. Thapa, Learned Council on behalf of Mr. S. Dotto, Learned Standing Council, Panchayat and Rural Development Department for the response number 1 and 2, and Mr. S.R. Borua, Learned Junior Government Advocate Assam for the response number 3 and 4. Postal. In the affidavit in opposition filed on behalf of the response number 2, it is stated that it is the liability to the extent of rupees 5,93,942.
43.
942.
3, Lordship.
In their statement, it is there. Affidavit.
942.
Page 37. 942
Lordship.
has been admitted as against supply of stationery items by the petitioner during the Panchayat election 2013. Full stop. The respondent number 2 has further admitted that has further stated that proposal from its end was duly forwarded. Proposal from its end was duly forwarded to the Commissioner, Panchayat and Rural Development Department. Full stop. It is further mentioned that the Office of the Commissioner, Panchayat and Rural Development Department in continuation of its earlier proposals, submitted a fresh proposal to the state government in the Panchayat and Rural Development Department by an office letter. Submitted proposals to the state government in the Panchayat and Rural Development Department on 9/6/2025 and 25/2/2026 respectively. Nine 6/2025 and 25/2. What is 25/2?
Return back entry. So we have requested the commissioner to submit the verified bills.
Requested for a certificate, your lordship, with respect of the verified bill, your bills, your lordship.
Okay, 9/6/2025. On 25/2/2026. On 25/2/2026. The Commissioner, Panchayat and Rural Development had requested the District Commissioner to furnish a certificate regarding validity of the bill/vouchers. Just to delay all this exercise, nothing else. This, that. Who is the respondent number 2?
Commissioner.
Commissioner লিখছে না? Post of Mr. Borua. Learned Junior Government Advocate for the number 3 and 4 shall obtain instruction whether the office, the respondent number 4 has forwarded the certificate in reference to the request of the Commissioner Panchayat and Rural Development, white its office letter dated 25/2/2026. Post of lays the case on sales.
8 April. Lordship, for a moment, kindly come to page 44, your lordship. 1C, your lordship. Annexure. Third line, your lordship. This Commissionerate of PNRD Assam has received bills, vouchers, photocopy enclosed for an amount of rupees so and so, only along with the certificate of SDO civil Dhokwakhana, which is due for payment, your lordship. Already they have received. It is from SDO Dhokwakhana. Now they are asking for all these
Page
things from
44.
Lordship. Annexure 1C.
No, finance department are devious. They can devise any excuse. Now they have this validity. They have found out with their brilliant mind. Mr. Borua, place the case on suspension.
8-4.
Finance is not a party.
Not a party.
Take a call. And they knowing fully well that they are not a party, so they will return back the proposal.
Item 20. Item number 20. Item 20.
May please the lordship. My lord, here in this case, my lord, the petitioners
Right.
My lord, they got the arms license and
How can you club all these gun licenses in one petition?
my lord,
How can you club?
my lord,
They have different causes of action, different gun license, different expiry period, different grant of date. And you clubbed all this in one petition. And see the answer of the Deputy Commissioner.
one more thing.
See, you read your affidavit. You read your affidavit. Read loudly. Let us for the benefit of all. What does he say? No. Read. First paragraph 4.
Text to state that there is no any data available. The office of the district commissioner of Affidavit, Contractor, Nagar, Assam.
Then 5.
With regard to the statement made in para 7 of the rate petition, the answering given in backs to state that the renewal of arms license is at the discretion of the district magistrate. Then, and the then deputy commissioner, Hodai perhaps did not consider it for renewal.
What is this? If discretion is there, whether discretion means simply he can refuse. Whether refusal is required to be with reason. And what is this word perhaps? He has exercised the discretion. Maybe his predecessor. So my predecessor had perhaps thought it fit not for refusal. For refusal. What is this? Huh? Is he fit to be a district commissioner?
Well,
Not happily worded.
when I
Huh?
me also.
Whoever not happily worded, I'll record this paragraph, I'll quote and not happily worded. Not happily worded, so another opportunity is granted, otherwise personal appearance. Heard. Mr. A.R. Sigdar, Plenary Counsel for the petitioner. And Mr. S.R. Borua, learned junior government advocate for all the respondents. Full stop. The 3 petitioners have approached this court by the instant petition. Your petition is also not happily drafted.
I would like to point out one thing at page 24 also.
If you want more,
No.
you want more example,
No.
huh? I have stopped at 1 paragraph. Should we read more? Then read paragraph 11. Or paragraph 9. What is this? What is this? Paragraph 9. You want to read more? 11. You want more, okay. I've approached this court after their applications for renewal of gun licenses have not been renewed by the district commissioner, Hojai. Hojai is still a district?
District.
Full stop. The respondent number 2, that is the district commissioner Hojai, has filed an affidavit in opposition. Full stop. Paragraph 5 and paragraph 9 and paragraph 11 of the affidavit in opposition, in paragraph, so it has been avoided as under, in paragraph, quote করে দিব. On perusal of the affidavit in opposition, this court finds that the affidavit in opposition is vague and ambiguous. Vague, ambiguous, and bereft of necessary details. In such view of the matter, the respondent number 2 shall file a comprehensive affidavit traversing the contentions of the contentions made in the writ petition within a period of 3 weeks without fail, lays the case on sales. A copy of this order is to be sought for, is to be supplied to Mr. Borua, learned counsel for the junior government advocate for the respondent number 2 and 3, for taking for all the for the state respondents, including the respondent number 2, for taking necessary steps from his end. Yes, Mr. Bhuya.
Prepared our affidavit and we have sent it for vetting it.
Okay, Mr. K. Deori, learned counsel for the petition is present. Mr. Bhuya. M. Bhuya, learned counsel on behalf of the appearing on behalf of the respondent PWD authority, has submitted that the draft counter affidavit has been sent for vetting.
We will be sending it.
Okay, is going to be sent for vetting, and the same, it is possible, and the same will be filed invariably within 3 weeks' time. He has just sought for listing of the case after 3 weeks. The price allowed, list the case on so and so.
Applies.
3 weeks over. 3 weeks over.
That Assam House.
Assam House.
Yes. Some progress has been made.
Gogoi has come.
Yes.
Some progress has been made. You have got the result from the Assam House Kolkata. This is my instruction. Now that it is the fidelity, we can move the proposal. And accordingly, my lord, will be released by the GAD department.
We feel like a mediator now.
Yes, my lord. I think some time, if you also put some time frame, I think it will take some speed. Otherwise, my lords, it's a very slow space going on, my lord.
Instead of my lord, posting it within 2 weeks, let it be my lord after 2 months, my lord. Because in the meantime, there will be election.
2 months, lordship may not be 2 months, my lord.
2 months after, no instructions are not received.
Yes, yes, my lord.
That is why because we don't want this kind of petition on board.
Yes, yes.
As if in place of we are sitting as a commissioner secretary.
Something like that. That's the feelings they are giving.
Don't feel good.
Various chances lordship is given to them.
What to write? Tell me.
Last page, my lord.
12th March later, my lord. Date nahi kuch.
This is 12 marks. This is understood.
Last page, additional chief secretary to chief engineer.
Possible indicate in the order that my lord, the respondents after 2 weeks will place my lord, by what time they will make the payment. Whether it's a PWD or the.
My lord, my.
That will be more convenient or not.
And Mr. M. Nath, Learned Senior Counsel, estate by Mr.
A Bhattacharya.
A. Bhattacharya, Learned Counsel for the petition, Mr. B. Goyal, Learned Additional Advocate General Assam for the state respondents. On the previous date of listing, comma 20/02/2026, comma that is second paragraph, second paragraph. Second paragraph past tense of লিখে দিব। Half of the file will use with instruction. Half of the file is with instructions.
That's why they will provide.
The other read petition, bulkiness of the read petition is lesser than the instructions. The read petition has been preferred. By the petitioner making a claim for a sum of rupees 16,31,795. Suppose that the petitioner has claimed this amount for works executed in the Assam House, Assam Bhavan.
Assam House.
Assam House or Bhavan?
Assam Bhavan, this is Salt Lake.
Additional Assam Bhavan, Salt Lake, Kolkata. Upon institution of the read petition, the respondents were put to notice on 7/8/2025. First off, for executing contractual question again, for executive, for extending consultancy services, comma, etc. Though no counter affidavit, no response in the form of counter affidavit has been filed on behalf of the state respondents till date, comma, instructions are being placed from time to time indicating the progress made for consideration of the claim made by the petitioner. First, the instructions from the instructions, placed from time to time, right? Since, not right, since, after 7/8/2024. Only conclusion that can be that is possible to be drawn is that the progress made so far is tardy. TARDY. Full stop. The buck seems to have been transferred from one authority to another. As a result, there is the claim made by the petitioner is yet to reach a logical conclusion. Full stop. The instruction placed before the court today in the form of an office letter, number so and so, dated 10/3/2026, from the Additional Secretary to the Government of Assam, GAD to the Chief Engineer, PWD Building, is in reference to a letter of the Chief Engineer PWD Building dated bearing number MIS/2 dated 8/7/2025. He is writing reference. See the last letter you have drawn attention to the court. He is writing on 10/3/2023.
26, right?
26 and making reference to a letter of. In the meantime, a bridge has been constructed over Brahmaputra.
Oh, yes, 2025. 8/7/25.
After 8 months, he replied.
In between, my lord, there are some, my lord, sitting between the petitioner and the.
The respondent authorities in the above view of the matter, the respondent authorities shall place instruction before the court on the next date as to within what time, period of time, the entire process as regards the claim made by the petitioner can be brought to a conclusion and to disburse the amount to the petitioner, disburse the amount entitled to the petition. When do you want? This is the case on 33.
3003. There are two letters, my lord, in page number 40 and page number 47. Lord, will find, my lord, the GD has written to the commissioner to make payment from the budget. Twice they made it, but still applies, my lord. Items 23 and 24.
No, this matter is settlement of Fishery. Can I have it any non-motion day? Can I have it?
26 March 2603.
My lord.
আছে নাই খালি আছে okay.
My lord.
Who is for the fishery?
That's Fishery will vote.
3 o'clock. As Kotoki, learned counsel for the petitioner is present. The learned counsel for the respondent fishery department is found absent today on call. It is submitted that the writ petition can be considered for disposal on the basis of the pleadings already filed. Full stop. Oh, Ms. Chakraborty, you are for whom? P. Chakraborty, you as a standing counsel.
No, it's for private.
For the respondent number three. SR Borua, Junior Government Advocate. No, list the cases on 26/3 to
2603.
Item 25.
Bina Pani hai. What is the destitute home?
Yeah.
Destitute, some destitute home.
Central destitute home. Meant to, my lord, give refuge to the people who came from East Pakistan in the year 1958.
Mr. Chakraborty, let us have it on a hearing date.
My lord.
After Bihu.
My lord. Otherwise, pleadings are already exchanged.
D. Chakraborty, petitioner A.K. Dr. CDC, and Mr. S.R. Borua, Junior Government Advocate for the official respondents are present. Sought for and agreed to by the learned counsel for the parties, list the case on after Bihu at a hearing date. Already get a fixed cross a guitar by
3004. 3004.
Deeply obliged.
Items 26 and 27.
Next week, release Yes, Mr. Khandokar.
My lord,
File. Okay. I had Mr. M.R. Khandokar, learned counsel for the petition, and Ms. P. Thapa, learned counsel, on behalf of Mr. S. Dr. learned standing counsel, Panchayat and Rural Development Department. Full stop. It is stated, Ms. Thapa has submitted that an affidavit in opposition has been filed on behalf of the state respondents. Full stop, para. As the said, affidavit in opposition of the state respondents is not on record. Let the case be listed on so and so with the said affidavit in opposition on record.
My lord, I have also received copy in the meantime. I will file a reply.
The petitioner, if petitioner may file its reply affidavit on or before the next date of listing, if so advised, list the case on so.
3003. 3003.
It may be on 884.
84.
842.
84. After we
Okay, 84. 84.
I'm deep.
Item 28.
23 pa, no? Next week to 23 pa, no? Huh? Oh, 60 pa. Yes.
Sometime to
28. Who has filed affidavit?
But I have filed a additional affidavit to bring on record the Jamabandi of the piece of land. But after filing of the writ petition, it was noticed that there are other co-partners in that plot of land. My main allegation was that the selected candidate offered land doesn't meet up with the required dimensions.
This is regarding petroleum outlets.
Petrol pump or retail outlet of HPCL.
That award or what? Tender bidding process.
Bidding process is over here. The private respondent has been selected. LOA has been issued. LOA has been issued. There is
LOA has been issued.
no interim in the case.
No interim.
No interim.
Okay.
Now I filed an additional affidavit to bring on record the Jamabandi, which shows that there are other co-partners. And
So you are questioning his eligibility.
he has filed his affidavit, my lord. Now the HPCL is required to produce the records because
Sorry, so this petition, you have petition, then you have filed an additional affidavit. And respondent number 6 has filed an affidavit. And Mr. Borthakur is without affidavit, right?
Yes.
Without affidavit.
No, I need to file it.
File.
Process, I have to file a additional evidence to complete this.
Okay, additional affidavit so that he may have to file.
At least the records of the land evaluation, my lord.
Yes, sir, obviously.
If the file affidavits. Are you filing
We are going to file.
or without fail?
Yes, sir, obviously.
Or otherwise, who is the respondent? Official?
I am for 1 and 2, my lord.
These respondents like HPCL, BPCL, NRL, IOC, oil will make the other bodies richer. Bar association,
No, no, my lord.
employees, that if don't file, 10,000. Right?
But today, not today, my lord.
Not today,
Yes.
next from that next day.
Navratna company, man.
Yes.
Navratna.
Navaratna. So that in some form CSR activities is carried out.
Yes, yes.
Right. I'm not pointing out to state respondents, but these authorities can do. They have their department, specialized subject matters.
Not the council, my lord.
No, the councils also. Heard Mr. P. Bhardwaj, learned counsel for the petitioner. Mr. S. Borthakur, learned counsel for the respondent number 1 and 2. Mr. S. R. Burwa, learned state counsel for the respondent number 3, 4. How a higher secondary education council?
One of the allegation was that he was not class 10 to qualified.
Where is it?
It has been stuck out, man.
Stuck up.
Stuck.
Okay. Cost title, new cost title.
Yes.
And Mr. M.R. Islam, learned counsel for the respondent number 6. Full stop. An additional affidavit on behalf of the petitioner has been filed, and the same is not yet brought on record. Full stop. The registry to trace out the same, to tag the same, to tag the additional, registry to trace out the additional affidavit, to tag it with a case record. Mr. Islam has sought for and is granted the 3 weeks time to file a reply, reply to the said additional affidavit. Full stop. It is noticed that the respondent number 1 and 2 have not yet filed its counter affidavit. Full stop. Mr. Borthakur has prayed for and is granted 3 weeks time to file the counter affidavit on behalf of the respondent number 1 and 2. Full stop. List the case on so and so. The respondent number 1 and 2 shall ensure that the counter affidavit is filed on or before the next set of listing, with an observation that failure to file the same would entail cost.
6th April. 6/4.
So nobody will be displeased. It will be to bar association.
Item 29.
But I am sorry, my lord, in item 26, my lord, can it be on 2nd of April, my lord? Here on 8, I have some problem.
Other Thursday, no. Already fixed matters.
Then, my lord,
6th of April.
6. And
May I please? Matter is non-payment of higher charge bill রয়েছে. They have filed affidavit, admitted the amount রয়েছে.
Yes, Mr.
Yes, Lordship, we have filed our affidavit on behalf of respondent number 2. Although he has claimed amount of rupees 66 lakhs 25,430. But the
Okay.
actual amount is 60 lakhs 88.
Okay, A. Dekar, learned counsel for petitioner, and Mr. S.R. Board, learned junior government advocate Assam for the official respondents are present. This is the case on Tuesday. Right, next Tuesday, we'll dispose of.
Within 4 months.
Tuesday.
It will list again.
Lots. Abla Lodge. 17. Lodge. 7.
This one.
Abla Lodge. Items 30 and 31.
So yes. Ready, all are ready.
Chief, we have to file an affidavit upon service of dusty notice, Lordship. So,
In which case?
Item number 4.
29 complete. All are represented. Item number 29. Oh, this is item number 30. I'm sorry. Sorry. 30. In 30, Ms. Chaudhary or who?
Lordship.
You are a petitioner. And Union of India represented. Numoligo Refinery represented. Respond number 3, 4, 5. All are represented.
Lordship, in item number 30 and 31, they have served the notice, but they are not appearing, Lordship.
No, one by one. Item number 30. This Sarma Tour and Travel, Roman Kumar Phukon, Subhasri Tour and Travels. All are served.
Dusty served, Lordship.
Okay. Okay, in 30.
Lordship, 31 I am appearing.
31. So what is your submission today?
Lordship, I'll bring the dusty affidavit on record.
Okay. In item 31. 30 also?
Lordship, item 30 and 31, Lordship, we have served the dusty to the private respondents, but they have not
Okay.
appeared. But in item number analogous matter, Lordship, 64 and 49.
So 31, Ms. Chaudhary, you want to file dusty affidavit.
No, not on the no, Lordship, item number
64 and 49.
64 and 49, the new cases, Lordship.
Supplementary.
64.
Same party. Analogous matter, Lordship.
Okay. I am looking at this. And you are making submission on 30 and 31.
Sorry, Lordship.
Some key is what we call it. 64, Lakshmi Prasad Bora.
And 49, Lordship, Jharna.
49 was here. Okay. 49. Chorna, so. No dusty. Miss B. Chaudhary, and Council of Petitioner. Mr. S.S. Royal and Junior Government, Central Government Council for the response number 1. And Mr. M. Gogoi, and Council for the response number 2. Full stop. Ms. Chaudhary has submitted that. And the notices upon the response number 3, 4, and 5 have already been served by way of dusty. And the compliance affidavit will be filed within a week's time. Right? Okay. Okay, you on the file. Okay. Mr. Gugoi has submitted that the counter affidavit on behalf of the respondent number 2 would be filed within 2 weeks' time. Okay. Item 64. B. Chaudhary. S.S. Roy. CGC 1. M. Gogoi 2. Same. 3, 4, and 5. Right. Prayer for NRL is same. to file counter affidavit. Second release the case on after 2 weeks.
3003.
3003/2026. এটা হল to. Then 29 to 30 also, same date?
Yes, Lordship.
Okay. Same date?
Same date.
Okay. Ms. M. Bora, Learned Counsel for the petitioner in WBC 6403/2025. Ms. B. Chaudhary, Learned Counsel for the petitioner in WBC 6412. Mr. S.S. Roy, Learned Central Government Counsel for the Respond Number 1, Union of India. And Mr. M. Gogoi, Learned Counsel for the Respond Number 2, Nungaligarh Refinery Limited. Heard. The Learned Counsel for the parties have submitted that exchange of pleading is complete.
Lordship.
And the matter be listed after 2 weeks to establish the cases on same date.
3003.
Lordship.
Order for 49 rupees.
Did you?
All same date.
Yes.
File your dusty affidavit. Let them file and I'll file their counter affidavit. It is on the same date.
Item 33.
Non-payment of contractual dues, Lordship.
Yes.
Affidavit was to be filed by the state.
File, not file.
Not filed, Lordship.
R. Hanuka, Learned Counsel for petition is present. Ms. M. Kolita, Learned Standing Counsel, PHE, has sought for and is granted further 2 weeks, 2 weeks time to file the affidavit, bring the stand of the respondents as regards the contractual amount claimed in this petition.
Date may be
Release the case on.
1st April, 1/4.
much of it.
Item 34.
With which, Lordship? Lordship, in this matter, an affidavit has to be filed, Lordship.
Mr. Bhuya, you
वो जो दिया वो हो गया.
Requested us to file a, they prepared a, we'll be sending it for vetting within this week.
Okay, Mr.
R. Gohai.
R. Gohai, Learned Counsel for a petition is present. Mr. M. Bhuya, Learned Counsel, appearing for the respondent authorities in the Health and Family Welfare Department has submitted that the draft affidavit, counter affidavit is going to be sent. It has been drafted and the same would be sent for vetting. So he has submitted that the counter affidavit can be filed within
10 days, sir.
Okay, 2 weeks time. The pay made by Mr. Pay for time to file counter affidavit made by Mr. Bhuya is accepted. Release the case on solution.
8th April, 8/4.
What's your guide, sir?
Item 35.
Yes. Mr. R.S. Mishra, Learned Counsel for the petition is present. Mr. A. Jahid, Learned Counsel for the respondents, has made it, has prayed for and is granted 2 weeks time to file the counter affidavit. Release the case on so and so. Interim order, if any, shall continue till the next release.
1st April, 1. Item number 36.
May I please? This is my non-payment of the contractor's bill, my lord.
Mr. K. Udin, Learned Counsel for the petition is present. Yes, department?
PWD, my lord.
The Learned Standing Counsel, Public Works Department for the respondents is found absent today on call. No affidavit, counter affidavit has been filed. on behalf of the respondent PWD authorities as regards the claimed amount of rupees 7,03,083. Close stop. Let, in view of non-representation on behalf of the respondents, let the case come up for insult justice be listed again on so and so. Close stop. The respondents shall file their counter affidavit, shall ensure that its counter affidavit is filed before the next date of listing.
1st April, 1/4.
Alright.
Supplementary list, item number 60.
Please, your lordships.
Hmm.
In this case, my lord, I have filed one amendment petition.
Amendment petition,
Yes, my lord. Amended of the cost title.
amended cost item.
Yes, my lord.
Who has been,
Respond number 1, my lord.
huh?
Respond number 1. It should be Commissioner and Secretary. Government para 2. Please, there. It was, my lord, in the main petition, State of Assam represented by the Commissioner and Secretary to the Government of Assam Dispute. Now it should be Revenue Department. Revenue and Digester Management Department having its office at Dispute. Para 2, last para.
Any order has been passed on it?
Yes, my lord, before that. Order has been passed. No? Where? We didn't know 3. Where? On when?
Your hands,
I don't mind.
huh?
7255.
The amended cost title in terms of any court order,
Yes, my lord.
ordered it
17/12/2025.
17/12/2025.
Wait. Yes, नहीं दिख रहा। Wait.
17/12.
Yes, my lord. ADB submitted that there has been an inadvertent error on putting the full description in respect of the respond number 1. That is order dated 17/12/2025.
17/12.
Para 2.
Para 2.
Yes. The KDB Learned Council appearing on behalf of the petitioner submitted that there has been an inadvertent error in putting the full description in respect of the respond number 1.
Okay. Heard Miss K. Devi learned counsel for the petitioner.
Should be actually we should.
Miss, you were for whom? Mr. Asa Burwa, learned junior government advocate Assam for the respond number 2 and 3. And Miss B. Bora. B for Bombay.
D Bora, D.
D. Bora.
Delhi.
Learned counsel for the respond number 4. Postal. Miss Devi has submitted that in deference to the order dated 17/12/2025, an amended cost title has been filed for correction stroke modification in the, in the name of the respondent number 1. Full stop.
I will take 2 steps also for that. Details.
The registry to correct the name of the respondent number 1 as quote, the state of Assam, comma, represented by the Commissioner Secretary to the Government of Assam, comma, Revenue and Register Management Department, comma, Dispur, comma, Gauhati, there's 781006, unquote. In the in the CIS, post up, release the case on next week, reflecting the name of the learned standing council, Revenue and Disaster Management Department in the respondent side the cost list.
2003. 2003.
Yes, highly obliged.
Item 61.
Mr. Council, I have to, because of some emergency, I have to close this for judgment. Right. I thought that I'll be able to deliver it because of some emergency. I could not. Repeat corridor. The arguments are heard. Judgment is easier. Maybe in the next week.
For orders, item 40.
My last
Yes.
one.
5. Good. SK Das for the petitioner. Contempt. Okay. Upaida, you appear for whom?
Others are 1 to 4 are retired or.
Okay.
Respondent number 4 has retired in February.
Mr. N. Upaida, Learned Council has submitted that he has instruction to appear on behalf of the respondent number
5.
5.
Asut Kumar 4.
5. And who is the civil engineer? Is he present or not?
Chief engineer also, he has retired in February also. Just few days back also. Again, after, I will.
Okay. Mr. Upaida has the name of Mr. N. Upaida, Learned Council, is to be reflected in the cause list. Mr. Upaida has sought for and is granted how much time? 4 weeks time to obtain instruction and to file the counter video on behalf of the respondent. You have to make the civil engineer party.
Lots.
Executive engineer say, I have sent the proposal.
Demand is already sent.
I have sent the proposal to chief engineer. There is no way out.
Also, in the writ petition, also there is a statement by the additional chief engineer. That is why also that admission.
Make the present one party.
Item 41.
Oh. He mentioned Kursil. Kursil. Okay. Morning, some mention was made for listing in the case after. Okay, 2 weeks for filing some impleading application. Nobody was there, he did not inform, okay. Prayer is made on behalf of the petitioner. Filing what we got to con. I say disposition. For listing of the case after 2 weeks, in order to file an interlocutory application for implement, or it is defective. Okay. In view of the above prayer, let a case be listed after 2 weeks. On a date to be fixed by the office. Same as again, next to same again. It will have to mention the allow kara nahi again. Okay, same order. Miss CA. In Lungi. 1, 2, 3. For 1, 2, 3 present, huh? Same duita.
43.
May this lordship, my lord, direction of this honorable court will find in page number 27, my lord, the relevant portion.
Have they filed anything? You said para?
17, my lord.
Page 17.
27, my lord. Page 27, para 17, my lord.
Para?
17. 27, page 17. My review order, my lord. The direction was to reinstate with immediate effect and the service benefit applicable. The petitioner will be released by the authorities as per provisions of law. The petitioner will be given the national benefit of his service and the seniority will also be protected, my lord. Here, though I'm reinstated, my lord, my national benefit has not been given, my lord. I'm drawing less basic pay.
Prime Minister of Service.
Lord.
How can it be? It's poor? Huh? It is range 4. Every benefit you have got.
My lord, I'm drawing less basic pay. My basic pay is very lesser than my page mate, my lord.
That may be for different reasons, but pay fixed notionally from 31/10/1996 to 14/10/2024. Areas amounting to rupees 3,31,296 for the period so and so is paid on 28/7/2025.
My lord,
All benefits have been given.
but the-
If some more grievance is there, then that is for to be hesitated in.
there is a specific direction of this honorable court is that to give national benefit.
That is what
Yes, obviously,
what
yes,
I have
yes,
read.
yes.
What I have read now, which specific to your notional benefit,
My lord.
pay fixed notionally
Mm.
from 31/10/1996 to 14/10/2024. You have been given all the benefit. If you are still aggrieved, I think that is a new cause of action. It is that pay notional 2 lakh has been paid.
My lord, yes, I read.
Yes. Order of dismissal that has been set aside, reinstated. Now you are going through a review board considered completed. First SCP you got it. Second SCP, MSCP you got it. Now third SCP is not entitled as per them, low benchmark. And sorry, the given notional benefit. And the seniority will be protected. Review DPC has been done. What more you want?
My lord, my basic pay should be revised along with my batchmate because as per
That you have to, that is a separate, with your batchmate and all, I think that is a separate cause of action.
Lordship may allow me some time so that I can pre-record the basic pay along with my.
Okay, next. Pidava,
Di Wapangla.
Wapangla, learned counsel for the petition. And Miss A. Gayon, learned counsel for the respondents. Heard. Miss Gayon has placed a letter bearing number 2026-1237 dated 26/2/2026 of the commandant CISF addressed to the Deputy Inspector General CISF NEJ HQRS Gauhati along with the covering letter dated 5/3/2026. Group Commandant addressed to her. Post of MS Gayan has submitted that she has permission to place the covering letter also. Post of before the court. Ms. Gayan, on the basis of the instructions so placed, has submitted that the petition, the direction made in the order dated 2/8/2023. 2/8/2023? In review petition number 89/2023 has been complied with. Post of Miss So-and-so, Wapangla, has however submitted that she will make further submission in the regard and has sought for listing of the case after we list the case on so and so. The instruction placed by Ms. Gayan is kept with the case.
2703. Item 44.
My lord, this is a miscellaneous application for restoration of a petition. So dismissed for default, my lord. This was dismissed for default on 19/8/2025.
1 minute. 19/8.
2025.
Yes.
Look, there was a miscommunication between the earlier persons who were looking after the matter, my lord.
What is this? This application is for what?
Well, challenging an award passed by the.
No. This application restoration.
This is restoration.
Where is 19/8/2025
It
order?
was dismissed for default. That is page
Restoration to go to the same court or by the bench?
not available.
Petition was dismissed, sir.
Huh? Whether is there any notification? I don't know. That is why I have asked. It should go by the bench or by the court? By the judge? Judge or by the bench? Any idea?
No, I don't.
No, not by the bench.
Not required.
Appropriate.
Okay.
Bench.
So once it is restored, the direction to grant benefit under section 17B should also be restored.
But if there was a delay, 51 days in filing restoration application.
That has been
On
condoned.
that last occasion, Lordship, that delay was condoned on, we had no objection, provided that we have paid before this court that 17B benefit, which was not to the petitioner, would be cleared by the time, Lordship. That's why restoration petition was not order, no order was passed. With that understanding that they would file as they would be cleared as 17B benefit to the petitioner, pending 17.
Even key.
Not 2023, but they have not paid as the last paid of it, 17B benefit.
Yes, with this, if we allow this,
That's it.
the writ petition will be restored to its original number,
That's it.
right?
That's it.
And the order,
That's it.
interim order, passed earlier on 27/3/2019,
That's it.
shall also be revived.
That's it.
And we'll ask him to comply within short period, 6 weeks, if no full compliance till then, till the date, right?
That's it.
Within 6 weeks, whatever arrears, whatever is there, they should pay. Otherwise, again, it will
That's why last present we have no any serious.
My last order, my lord, in delay condonation petition, I was directed to take instruction because, my lord, I was not the earlier counsel, my lord. I took instruction, my lord. The thing is that, my lord, he has resigned earlier, that's the
That's not
fact, my
very
lord.
good.
Yes, my lord. He was resigned from the BATA, the present petitioner, then joined a new company. Then finally it was ordered that we should reinstate him in our service. That's our grievance, my lord.
Award is there for reinstatement,
Yes.
right? Award is there for reinstatement.
Yeah.
On 27/3/2019, order direction is made that 17 benefit should be extended, right?
Thereafter also 17, 12, 21 and 1 for 25.
The original order, 27/3/2019. Then ultimately it was dismissed. Do you have anything to say that he is gainfully employed all this?
That's what, my lord.
Huh?
We are not saying he is gainfully employed, but he has submitted an affidavit way back in 2018, my lord. That's also, I am being told, my lord, because whether in 2018 he filed an
Sharma,
yes, my lord.
read petition is of 2017.
Yes.
Meaning about the award is of sometime
15, 2015.
They have filed after 2 years.
After
As per
2
the
years.
petition, from the date of award till the filing of writ petition or the order passed in 2019, they have not paid me plus pay lordship, 17B. And thereafter lordship, last payment was I received on lordship 2024 lordship. 11, 12, 24. Thereafter no payment. Then thereafter the matter is gone.
This direction stands restored also.
Yes, and that will stand restored, my lord.
And you comply with whatever is there within period of 6 weeks. There is no escape from it unless you
Yes.
say that he is gainfully employed somewhere.
That's what, my lord. I have communicated whatever he has calculated and given it to me with my company, my lord. They say they are taking instruction in the regional basis, my lord, at the locality, whether he has been gainfully employed or not, because he has filed an affidavit in 2018 saying that he was not gainfully employed.
Where affidavit
My
filed?
lord, in the writ petition. In the writ petition, he has filed he was not gainfully engaged anywhere, the respondent number 1. After passing of the order by the learned labor court.
Huh?
Now, my lord, presently, if he has been engaged somewhere, my lord, then
That
my
is
lord,
ifs and buts will not do.
my lord, we can, my lord, we can pray
Come
for
up
a
with
fresh,
instruction, then we will restore this.
They have paid also.
we can pray for a fresh affidavit.
When it
by-
was, you comply till 19/8/2025 at least.
Yes, my lord,
Till the
then,
date of dismissal you comply.
yes, my lord.
Thereafter we will restore this.
Yes,
17B, you must do it. Ultimately, it is an order, direction of the court.
yes, my lord. I am,
Whether he gainfully employed or not, that is a matter we will examine.
another option is given to me, my lord. I have talked with him also. If you can go for mediation and settle it, it will
Definitely you
help,
can
my
go
lord.
for mediation.
That I have proposed him, my lord, but I don't know, my lord.
Then
That's
he
instruction.
can waive off the this thing after 19/8. First you comply with 19/8. Up to 19/8. Date
Yes,
of
my lord.
dismissal of the
Date of
writ
dismissal.
petition. Do it. In the meantime,
Yes, my lord. You get it.
but this will be difficult to pass such an order in this case.
So let them,
My lord, may I pray?
Let it be restored.
yes, now let them comply or
No, my lord,
No,
let the
this
petition
is
be
a matter
restored.
of restoration.
Yes.
This aspect, whether this is simply dismissal of the writ petition.
I'll understand if maybe an undertaking that it will be complied, then I have no objection. I have that faith on my.
The undertaking is not required, my lord, when
So,
there is an order of the court. My lord.
He can take instruction.
I can take instruction, ma'am.
Take on the next thing. Allow me to take.
I'm Mr. T.R. Sharma, learned counsel for the petition applicant, and Mr. P.P. Doctor.
So number 1.
No, no, there are two respondents.
Learned
1. So, you can-
counsel for the respondent number, opposite party number 1. Full stop. The instant application is preferred seeking restoration of a writ petition, WBC number 2274/2017 by recalling an order dated 19/8/2025, full stop. On 19/8/2025, when the writ petition WBC number 2274/2017 was listed for consideration, the learned counsel for the petitioner, the petitioner was found unrepresented, full stop. Noting that on 3 earlier occasions, also that is on 8/5/2025, 5/8/2025, and 12/8/2025, there was non-representation on behalf of the petitioner, full stop. Observing that such non-representation indicated about losing interest in the proceeding, the writ petition was dismissed for non-prosecution. Interim order, if any, was also stand vacated. Full stop. Para. The applicant has explained the reason for non-representation on the aforementioned occasions to pursue the writ petition in paragraph 3 of the application, full stop. Having gone through the statements and awareness made in the instant application, more particularly, in paragraph 3, this court is of the considered view that the applicant has been able to explain the reason for non-representation on the aforesaid 4 occasions, showing sufficient cause. First of, in such view of the matter, in view of the above, the writ petition stands restored to its original number. The in violation, the order dated 19/8/2025 stands recalled. Consequently, the writ petition WBC number so and so stands restored to its original number. First of, as by the order dated 19/8/2025, the interim order which was in operation as on 19/8/2025 was also recalled, the interim order which was in operation as on 19/8/2025 stands also restored. Full stop. Para. Mr. Doctor, learned counsel for the petitioner, opposite party number 1, has submitted that as on 19/8/2025, the direction made for compliance of the provisions of Section 17B of the Industrial Disputes Act 1947 was in operation, and it is that direction under 17B is to be complied with for a rehearing of the restored writ petition. Post para. The writ petition, the office to restore the writ petition and to release the same. To stop. In the meantime, the applicant's writ petitioner shall comply with the direction made in the or interim direction made under section 17B. Meaning thereby the amount required to be paid by the applicant with petitioner under section 17B of the ID Act till 19/8/2025, comma, if not paid to the opposite party number 1, comma, shall be paid to the opposite party number 1.
Obliged. 45.
With the above directions and the above observations made and directions made above, the instant application stands allowed.
My name.
PP Dotto.
In the cause, my name was not shown.
The original petition was set open.
You have a contact with your client or not? File a this will be okay. The name of the councils. When the petition is listed, after the name of the learned counsel for the parties, as in the original petition, are to be reflected in the cause list. Now you have to file.
Yes.
You file.
Obliged. 45.
May I please, your lordship? As per office note dated 11/3/2026, the service report is awarded in respect of respondent number 6.
Okay. Mr.
A. Malik.
Malik,
A.
petitioner.
Petition.
A. Malik.
A. Malik.
S.R. Borua.
Number 5.
5. Peruse the office note dated 11/3/2025. Full stop. The case be placed before the Lodgema Court for report as the service of notice upon the respondent number 1. Upon the respondent number 6. And thereafter to release the case on so and so with the report of the Lodgema Court.
Blessed.
1st April, 1/4. Item 46.
Yes, ma'am.
Your Lordship, in this matter, I have taken steps, my lord. Your Lordship may produce office note dated 11/3.
Yet to be delivered. Let us await then.
Yes.
And Miss A. Varasanji, learning counsel for petitioner, peruse the office note dated 11/3/2026. Await for the service report in respect of the respondent number 1. List the case, respondent. List the case on switch.
6th April, 6/4.
LCR, TCR pale.
It has come. Okay.
Item 47.
Your Lordship, this is an application seeking interim relief, Your Lordship. In the main petition, the petitioner is seeking verifiable credentials, Your Lordship. He is already.
Okay, we'll give consideration on Tuesday.
Main matter is coming on 25th. So in the meantime, we'll file affidavit. Otherwise, you see it will be allowed to.
No, actually, it is very,
Yes, sir.
well, whatever is there, if time permits, on Wednesday we will decide. This one?
Your Lordship, I have it on the 20th, Your Lordship. I have another matter. I'll be here on the 20th, Your Lordship.
Okay. Mr.
Harsimrat Randhawa.
H. Randhawa. For the applicant, Mr. K. Goway. When the other case is state.
Other day is on 25th. Lordship.
Main case is
Okay,
on the 20th.
next.
Lordship, no,
May have it on the 20th, Your Lordship. I'll be here.
Okay, it's coming. Time permits 2020.
Highly obliged.
If time permits, this I on 20.
Lordship.
And if required, we'll consider. If I don't find Sufficient time. Here go, Central Government Council. As sought for and agreed to by the Government Council by the parties, release the case on 2003, 2026.
Item 48.
Highly obliged.
May I please, Lordship?
Release the IO, release the
Lordship, this IA is filed for extension of some 4 months time to comply the order, Lordship. Lordship, what happened earlier, the petitioner approached this honorable court for release of his outstanding contract bill amount, Lordship, of 24 lakhs, more than 24 lakhs, Lordship. And Lordship has disposed of the matter, directing the authorities to release the outstanding amount within 4 months, Lordship. Here, Lordship, what happened, the contract was
I
executed.
think notice is to be issued,
Lordship. Lordship.
then only this man is from which place?
He is from
Gauhati only, okay.
Lordship.
Her Miss R. Devi, Learned Council for the applicants. The instant application, interlocutory application is preferred, seeking extension of time to comply with with the direction made in an order dated 8/9/2025, passed in a writ petition WBC number 530/2025, post of. In the order dated 8/9/2025, a direction was made
Page 12.
to release an amount of rupees, to pay an amount of rupees 24,83,037 within a period of 4 months from the date of receipt of a certified copy of this of the order by the respondents. Full stop. The applicants have averred that the necessary amount, the amount is to be received from the Central Silk Board, as the Central Silk Board has not yet released any fund to the CPWD. The occasion has arisen for seeking extension of time. Puस्तक. Issue notice returnable on so and so. Steps upon the opposite party
That's
by speed post within 2 working days.
22nd April.
27. Obliged.
Supplementary list, item 62.
My lord, as per the Lawazima order, my lord, service is complete.
Okay,
So, my lord, the matter may be.
as
listed
we
for
chose with the
petition-
petitioner,
petition hearing.
Ms. Thapa, Learned Council, on behalf of S. Dr. Panchayat and Rural Development Department for the respondent number 1, 2, 3, 5, 6, Mr. S.R. Borua, Learned Junior Government, Pugir Assam, for the respondent number 7, are present. Full stop. As per order dated 6/3/2026, service of the Lawazima Court, service of notice upon the respondent number 8 is complete. Full stop. As notices have been served upon all the respondents, lease the case, office to lease the case for admission. Office to lease the petition in the admission column on so and so.
Short date may be given because the. my-
Short date.
30/03.